contentions are kept open.
Please, my lord.
IPF or
6 may be taken on Tuesday, my lord, so I filed compliance affidavit, my lord.
ಏನಿದು ರಿಟ್ ಏನಿತ್ತು, ಕಂಪ್ಲೈನ್ಸ್ ಏನಿದೆ ತೋರ್ಸ್.
Split, my lord, since the case was registered.
complainant before this honorable court is a student.
Ah.
The university had passed an order debarring her from appearing for the next 2 examinations. That was challenged before this honorable court. This honorable court quashed the order passed by the university and directed the university that the petitioner will be entitled to all the consequential benefits and permitted to answer all the examinations ensuing or currently progress in case. From 3rd semester to 7th semester, her marks cards have not been issued.
In complaint.
It was sent to the college, my lords, and I will file an affidavit, my lord, since the results were announced and we published the results also.
But time ಕೊಡಲ್ಲ.
I'll-
Call Monday.
Please, my lord.
Reluctantly posted to Monday. ಬೇರೆ time ಕೊಡ್ಕೊತ ಹೋದ್ರೆ
I
ಇದಾಗ್ತದೆ.
will file compliance affidavit, my lord.
So meanwhile, compliance to be reported.
Please,
Otherwise,
ma'am.
something bad will happen to the answering respondent.
It may be taken on Tuesday, my lord.
Tuesday.
Please, my lord.
No.
Kindly pass over, my lords.
My lord,
ಬಸವ.
Please, my lords.
the direction, my lord, is to conduct a joint survey and take appropriate action ಅಂತ.
ಮಾಡಿದಾರ?
ಮಾಡಿದ್ದೀನಿ, my lord. I filed a detail affidavit, my lord.
ಜಾಯಿಂಟ್ ಸರ್ವೆ ಮಾಡಿದಾರ?
ಮಾಡಿದ್ದೇವೆ.
ಮುಂದೇನ್ ಮಾಡಿದ್ರು? ಜಾಯಿಂಟ್ ಸರ್ವೆ ಮಾಡಿದ್ಮೇಲೆ ಮುಂದೇನ್ ಮಾಡಿದ್ರು?
Joint survey ಮಾಡಿ, my lord.
ಹಾ. ಮುಂದೆ?
2 orders, my lord.
ಹಾ?
You also kindly see, my lord, there is 2
ಆರ್ಡರ್
orders.
ಏನಿದೆಪ್ಪ?
Please, my lord.
Page number 81, my lords, including effecting subdivision of the properties in accordance with law, my lords. Hence not fully complied, my lords.
ಹೇಳ್ತೇನೆ.
Page number 81, my lords.
ಪೇಜ್ ನಂಬರ್
81.
ಸರ್ವೆ ಕಂಡಕ್ಟ್ ಮಾಡಿ ಮುಂದೇನ್ ಮಾಡ್ಬೇಕು?
ಮುಂದೆ ಮೇಡಮ್ ಅವ್ರು ಹೇಳ್ತಾರೆ ಅದನ್ನ ಇನ್ಕ್ಲೂಡಿಂಗ್ ಎಫೆಕ್ಟಿಂಗ್ ಸಬ್ ಡಿವಿಷನ್ ಮಾಡಿ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ.
ಹಾ, ಮಾಡಿದ್ರಾ?
ಇಲ್ಲ, ಸಬ್ ಡಿವಿಷನ್ ಮಾಡಕ್ ಬರೋದಂತ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಮಾಡಿರಿ ಅಂತ ಆರ್ಡರ್ ಇದ್ದಾಗ ನೀವು ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ ಇಂಟ್ರೆಸ್ಟ್.
ಅಲ್ಲ ಅಂದ್ರೆ ಎಂಡೋರ್ಸ್ ಮಾಡಕ್ ಬರೋದಲ್ಲ ಅಂದ್ರೆ ದ ರೀಸನ್ ವೈ ಇಟ್ಸ್ ಗಿವನ್ ಡೀಟೇಲ್ಸ್ because there is a OS is pending number 1, not if see my endorsement with respect to subdivision 6/11/23 the endorsement.
ಅಲ್ಲ, ಸರ್ವೆ ಮಾಡಿದ್ರಿ.
Please,
ಸರ್ವೆ ಮಾಡಿದ್ಮೇಲೆ ಸರ್ವೆ ರಿಪೋರ್ಟ್ ಜೋಬ್ನಲ್ಲಿ ಹಾಕೊಂಡು
ಇಲ್ಲ ಅದನ್ನ ಕೊಟ್ಟಿದೆ, ಸರ್ವೆ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿದೆ.
ಕರೆಕ್ಟ್. ಅದನ್ನ ಏನ್ ಮಾಡಕ್ ಮುಂದೆ ಅದನ್ನ ಇಟ್ಕೊಂಡು? ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಆಕ್ಟೆಡ್ ಅಪಾನ್. ವಾಟ್ ಫಾರ್ ಸರ್ವೆ?
What is claiming is subdivision of not how it's not ಅದಕ್ಕೆ the endorsement ಅಲ್ಲಿ the reason why it was
ಸೂಟ್ ನಲ್ಲಿ ಏನಾದ್ರು ಮಾಡಬಾರ್ದು ಅಂತ ಹೇಳಿದಾರ?
No, my lords, there is no step.
ಡ್ಯೂಟಿ ಸ್ಟಿಲ್ ಪೆಂಡಿಂಗ್.
pending.
My lords.
ಏನ್ ಮಾಡಕ್ ಮಾಡಿ ಸಬ್ಜೆಕ್ಟ್ ಟು ಔಟ್ಕಮ್ ಆಫ್ ದ ಸೂಟ್.
ಅಲ್ಲ ಅದಕ್ಕೆ ನೋಡಿ ಆಫೀಸರ್ ದ ರೀಸನ್ ಇಸ್ ಮಿಲಾಡ್ ತಾವು ಒಂದ್ 2 ಲೈನ್ ಇದೆ ಅದೇ
ಹೇಳಿ. 142.
ಹಾ 1 ಅಲ್ಲ 6/11/20 ಮೈ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಅದಕ್ಕೆ ಒಂದ್ ಸ್ವಲ್ಪ
Orders of the court, the apex court say, have to be construed, not keeping the common sense in cold storage ಅಂತ ಹೇಳಿದ.
it's true ಮಿಲಾಡ್.
With common sense you have to construe the orders.
ಮೇಲಿನ may just read ಮಿಲಾಡ್, it's a short order.
Which paragraph?
para 10 only ಒಂದೇ ಪ್ಯಾರಾಗ್ರಾಫ್ ಇದೆ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಮಿಲಾಡ್. ನಾನು ನನ್ನ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದೆ.
Endorsement ಅಲ್ಲೇ ಇಲ್ಲ.
ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿ ಜಂಟಿಯಾಗಿ ಹದ್ದು ಬಸ್ತು ಹಾಗೂ ಪೋಡಿ ವಾಟನೆಕಾರಗಳು ಉಲ್ಲೇಖ ಒಂದರ ಆದೇಶಂತೆ ವಾದಿರಾದ ನಿಮಗೂ ಹಾಗೂ ಪ್ರತಿವಾದರಿಗೆ ಮುಂಚಿತವಾಗಿ ನೋಂದಾಯಿತ ಅಂಚೆ ಮುಖ ಅಳತೆ ತಿಳಿಸಿ ಅಳತೆ ಕಾರ್ಯ ಕೈಗೊಂಡು ದಿನಾಂಕದಂದು ಗಡಿ ನಿರ್ಧಾರಣದ ವೇಳೆಯಲ್ಲಿ ವಾದಿಯರು ಪ್ರತಿವಾದರು ಮತ್ತು ಹಾಜರಿದ ಗ್ರಾಮ ಸಮಕ್ಷ ಗಡಿ ನಿರ್ದೇಶನ ಇರುತ್ತದೆ. ಯು ಆಲ್ ಸರ್ವೆ ನಂಬರ್ ಪೋಡಿ ಕಾರ್ಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸರ್ವೆ ನಂಬರ್ ಎಲ್ಲ ಹಕ್ಕುದಾರ ವಹಿವಾಟು ಅನುಸಾರ ಕ್ಷೇತ್ರಕ್ಕೆ ತಾಳಿ ಇಟ್ಟು ಅಳತೆ ಮಾಡಿ ನೋಡಲಾಗಿ ಶ್ರೀ ಪರಪ್ಪ ಕಲ್ಲಪ್ಪ ಉರ್ಬೆನವರ್ ಹೋಗಿರೋದು ಶ್ರೀ ಯಲ್ಲಪ್ಪ ಇವರು ವಹಿವಾಟಿಗೂ ಹಾಗೂ ಕ್ಷೇತ್ರಕ್ಕೂ ವ್ಯತ್ಯಾಸ ಇರುವುದನ್ನು ಕಂಡುಕೊಂಡು ಸದರಿ ವ್ಯತ್ಯಾಸ ಕ್ಷೇತ್ರಕ್ಕೆ ನಕ್ಷೆ ಮಾಡಲು ಚಕ್ಬಂದಿ ಕುರಿತು ವಾದಿರಾದ ನೀವು ಹಾಗೂ ಪ್ರತಿಯೊಬ್ಬರು ಯಾವುದೇ
ಚೆಕ್ ಬಂದಿ ಡಿಸೈಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ಏನಾರ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡ್ಬೇಕಲ್ಲ ಅವರಿಗೆ.
ಅದನ್ನೇ ಮಾಡ್ತಾ ಇದ್ದೀವಿ.
Produced, my lords.
ಈ ಲೆಟರ್ಸ್ ಈ ರೀತಿ ಅಂತ ಸೂಟ್ ಈಸ್ ಪೆಂಡಿಂಗ್.
Suit itself is pending for the declaration of the.
ಡಿಕ್ಲರೇಷನ್ ಆಫ್
There is suit is pending for the, my
what
lord.
is declaration in the suit?
My lord,
Declare that I am the
the
Raja
suit-
of this particular area. What is the
happened-
declaration you are sought for?
Please, my lords.
ಯಾರ್ ಸೂಟ್ ಅದು?
My suit,
ಹಾ,
there are
Read proviso to section 135 of the Land Revenue Act. Padi, Land Revenue Act padi. Toli. Namo papers, namde book, fee nimdu.
Sorry.
Toli. Proviso to section 135. Read.
Bar of suits. No suit shall lie against state government or any officer of the state government in respect of a claim to have an entry made in any record or register that is maintained under this chapter or to have any such entry omitted or amended.
Therefore, everything should be done in accordance with the decree to be passed in the suit. Correct? Huh? That's how courts have interpreted from the days of Honorable Chief Justice Govind Bhatt Saab. Okay, now your suit is pending. You get a decree, they will comply with the decree, whether they are parties or not. They are bound to comply in terms of proviso to 135. That's how we have structured the law.
Not,
Okay.
sir, sorry, Mr. kindly pass over, my lords.
I will
Please.
say that you have argued
Sir.
everything.
Sorry, my lords, kindly pass over, my lords, please.
The complaint alleges violation of a learned single judge's order dated
7/8/2020
7/8/2023
and 9/8/2023.
and the being spoken to order dated 9/8/2023.
2023.
First, after service of notice, the respondents having entered appearance through the learned GA have filed affidavit of the Assistant Director of Land Records, namely Mr. Ravi Kumar Hadimani. The affidavit is accompanied by the sketch drawn after the survey done pursuant to the mandate of the learned single judge and the Panchanama in support thereof. They are at document numbers D1 and 2, documents number 2, 1 and 2. Thereafter, a notice has been issued on 6/11/2023 in that connection to the concerned complainants, concerned parties. First up, learned GA, next paragraph, learned GA submits that there is a declaration suit in OS number
9 of 2020.
9 of 2020,
20.
wherein the subject property is comprised, and therefore he adds that in terms of mandate of proviso to section 135 of the Karnataka Land Revenue Act 1964, further step would be taken even if revenue officials are not parties thereto. First, in our view, this would suffice. This would suffice. First, added, there is substantial compliance of the order. First, in the above circumstances, these proceedings are liable to be and accordingly dropped, reserving liberty to the complainant to work out his remedy against the subject endorsement elsewhere in accordance with law. First of all, those contentions are kept in reserve.
Please. It's appearing for the accused. It's against the
There was an order.
order, my lords. The corporation, my lords, has filed an SLP before the Supreme Court. Therefore, my lords, I request a 10 days accommodation. I'll come back to court, my lords, with. May I, my lords?
We are told by learned panel counsel appearing for the answering respondents that an SLP is already preferred against the order whose violation is complained of. First, in view of that, as a final chance, a period of 2 weeks is granted.
Please.
Call up to 2 weeks.
appear for
Yen
claimants,
Bankar.
in the case of death, liability on the owner, no insurance policy. But the 25 lakhs has been awarded. So far as enhancement is concerned, my lord, There is hardly any scope for enhancement.
Huh?
Hardly any
No
scope for
scope for
enhancement. No
enhancement.
scope for enhancement. Owner liability,
Foundational facts could be owner's liability.
owner's liability. My lord, immediately after the accident, my lord, owner has sold the property with the standing in his name. After the accident.
After the
I
accident,
mean, after the award. After the award.
after the award.
After the award.
Yavudu section 53
Yes,
of the Transfer of Property Act. Toli. Read 53.
54.
Padi.
Fraudulent transfer.
Yes.
Every transfer of the immovable property made with an intent to defeat or delay the creditors of the transferor shall be voidable at the option of any creditor so defeated or delayed. Nothing in this subsection
So
shall.
you have to take action
Yes.
pursuant to that now.
Yes.
Yes, what is there?
My
For
lord,
enhancement?
25 lakhs 14,424 is the award amount, my lord. We have 525,000 deposit as statutory, this one, my
For the
lord.
owner,
He's for the owner.
Owner,
owner.
my lord.
Huh.
And then subsequently,
Yardu, appeal yardu.
My lord, I have also filed the cross appeal for enhancement.
that's what, my lord. So my
Appeal
request,
cross
my
appeal.
lord-
You are challenging that it's an excess award. Excess award antana.
ಇಲ್ಲ ಸರ್ ಹಾಗೇನಿಲ್ಲ
ಹ?
ಅದ್ರ ಜೊತೆಗೆ ಇದನ್ನ ಹಿಯರಿಂಗ್ ಇಟ್ಬಿಟ್ಲೆ ಬೋತ್ ಶುಡ್ ಬಿ ಟ್ರೈ ಟುಗೆದರ್ ಅಂತ MFA
Yes, we are doing
job
that.
is to be connected. It's
ಎಲ್ಲಿದೆ
not,
ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್
Connected. Connected.
ಆರ್ಗ್ಯೂ ಮಾಡಿ 2016 ಮ್ಯಾಟ್ರ್ 8 ವರ್ಷ ಆಗಿದೆ.
my lord, I am a proxy counsel on record is.
ನೋಡಿ ಎಷ್ಟು ಹೆಂಗ್ ಮಾಡ್ತೀರಿ ನೀವು ಗೊತ್ತಾ? ನಾವು ರೆಡಿ ಇದ್ರು ನೀವು ನಡೆಸಲ್ಲ, ಆಮೇಲೆ ನಾವು ಅಜರ್ನ್ ಮಾಡ್ತೇವಿ ಅನ್ಕೊಂಡು ಕೆಲವು ಕಡೆಯಿಂದ ಮಾತು ಬರ್ತದೆ. ನಾವು ರೆಡಿ ಇದ್ದೇವಿ, ನೀವು ಮಾಡ್ತಾ ಇಲ್ಲ.
Short accommodation.
2 weeks.
I request on Monday, my lord.
ಇಲ್ಲಿ ತಿಂಗ್ ಆಗಲ್ಲ.
Minor daughter.
Not 2 weeks.
Please.
ಅಲ್ಲಿ reluctantly adjourned by 2 weeks at the request of counsel for the appellant.
The respondent has filed the withdrawal of the compensation amount, my lord, which
argue ಮಾಡಿ.
already
Yes,
given on
madam.
17/11/2021, madam. Permission is already granted, madam.
ಹಾ?
Permission is already granted to the withdrawal of the compensation amount on
ಆಯ್ತು,
17/11/2021.
ಬಂದದ್ರಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬಿಡಿ. 2018 ಮ್ಯಾಟ್ರು
My lord, will file a brief finances, my lord.
2018ಗೆ 2013 ಏನ್ ಸಿನಾಪ್ಸಿಸ್ ಏನ್ ಸಿನಾಪ್ಸಿಸ್
Will file a brief finances, my lord.
Huh?
Recently, I got a
38. Come to page 38. Per gunta 56,000 ಇದೆ. $34 lakhs ಆಗತ್ತನೋ?
Yes, my lord. As per apex court judgment, Hirabai versus land acquisition judgment, my lord, it's held that the adjacent land beyond 3 kilometers cannot be considered for the determining the compensation, my lord. We'll produce it on next week, my lord. It can be disposed of, my lord. Next week, any date.
ಬರ್ಸಿರಿ.
Next week, any date may be fixed, my lord.
ಏನು ನಾವು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಕಾದ್ ಲಿಸ್ಟ್ ಬೇಕಾ? ಏನು ಹಿಂಗೆಲ್ಲ ಮಾಡಿದ್ರ ವಿಕಮ್ ಹೆಂಗ್ರಿ ಎಷ್ಟು ವರ್ಷ? 2013 LIC 11 ವರ್ಷ ಆಗಿದೆ ಅಲ್ಲಿ. ಟ್ಯೂಸ್ಡೇ
Please, madam.
It's a common judgment, no?
Yes, my lord, common judgment, my lord.
Common judgment,
Same.
7. Only one common judgment. Yes, ma'am.
Authority, my lord. Yes,
Tuesday. Reluctantly adjourned to Tuesday at the request of counsel for the appellant, panel counsel for the appellant. Nigama. ಅಲ್ಲಿ ಡಿಲೇ ಎಲ್ಲ ಕಂಡೋನ್ ಮಾಡೋಣ 13.5 ಅಲ್ಲಿ 184 ಡೇಸ್ ಇದೆ
please, madam. Please, madam.
application the appeal ನೋಡಿ MFA 100863 of 2019 is filed after booking delay of 183 days. First up, an application supported by an affidavit is filed seeking its condonation. Full stop. The explanation offered being found plausible, comma, application is allowed and delay is condoned. Call Tuesday.
Please, madam.
Already served copy to the other side.
When
Ah,
Already I have served, my
The petition
junior
filed.
has served the copy, but she has refused, one copy is given
when
today.
the matter was
refuse
referred
ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
to, sorry, Your Lordship, when the matter was referred to the mediation, they want to get the order modified, Your Lordship.
anyway, application ನೀವು ಅಪೋಸ್ ಮಾಡ್ಬೋದು ಇಸ್ಕೊಳ್ದಂಗಿದ್ರೆ ಮಿಸ್ಕಂಡಕ್ಟ್ ಆಗ್ತದೆ
It was
ಅದು.
before the mediation and the order was,
Please understand.
please, please.
Whatever
I'll-
pleadings are filed, you are bound to receive.
Please.
Otherwise, you will be
Please.
dishonoring
Sorry,
member
Your
of the bar. That
Sorry,
will be
Your
contempt of the bar. Therefore, you can oppose that application. You can't refuse to receive application. You can oppose it tooth and nail.
Please, Your Lordship. With
Mediation ಗೆ ಹೋಗ್ಬೇಕು ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ.
ಹೋಗ್ ಬಂದಿತ್ತೆ ಸ್ವಾಮಿ.
Your Lordship, I request for further one set copy to be due to oversight, it could not
ಅಲ್ಲೇ
be given.
ನಿಮ್ ಕೇಸು ನಿಮ್ ವಾಯ್ಸ್ ಎರಡೂ ವೀಕ್ ಇದಾವೆ.
Yes, Your Lordship.
Ah.
Due to oversight, it could not file another set of this one. Any short next accommodation be given. Next
Mediation
will be
ಯಾವತ್ತಿದೆ?
given. Mediation already
Petition-
finished, Your
ಆಗ್ಲಿಲ್ಲ.
It
Lordship.
is referred
ಆಗ್ಲಿಲ್ಲ.
back, Your Lordship.
Agli-
ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ.
ಮೇನ್
Next
ಮ್ಯಾಟರ್
will
ಹಿಯರ್
be-
ಮಾಡ್ಬೇಕಾ?
May I make a submission, Your Lordship? On last date of hearing, Your Lordship, on 26/3/2024, Your Lordship, this honorable court was pleased to order to pay the litigation expenses, Your
Litigation
Lordship.
expenditure ಕೊಟ್ಟಿರಾ?
For
It- the- it is the-
modification of the said order, application is filed, Your Lordship.
This is the
on
application for
18/4/20
modification of that order, Your Lordship.
Yes.
Please.
Litigation expenditure ಕೊಡ್ಬೇಕಲ್ಲ. ಅದಕ್ಕೆಲ್ಲ ಏನು
Because,
modification?
the reason obviously, Your Lordship, is this respondent is doing a garage worker and he is getting only sum of rupees 7,000 per month salary, even though he is qualified. So some leniency, some amount be reduced. For
ಎಷ್ಟು
that
reduce
reason,
ಮಾಡಿ? 10,000 ರೂಪಾಯಿ?
50,000 ಇದೆ.
10,000?
50,000
50,000
ಆಗಿದೆ.
is ordered, Your Lordship.
Some
50,000.
amount be reduced.
Please.
Some amount
And
be
she's
reduced so
having
that
a
he can
child,
pay.
Your Lordship.
Child
And
is
a
also
child,
there.
and the divorce is obtained when, during the COVID period, when she was with him only, Your Lordship.
Cruelty ground, there is a detail order, Your Lordship.
ಟೈಮ್ ಕೊಡೋಣ ಈಗ
But apart
25,000
from that-
ಕೊಡಿ ಆಮೇಲೆ ಒಂದು 25,000.
Your Lordship, already she has filed a case before maintenance before Bijapur court and already it has reached final stage. So at any moment, the award may be made in that case of Your Lordship.
ಅದು ಮೇಂಟೆನೆನ್ಸ್ ಈಗ.
Yes, Your Lordship.
Litigation
So
expenditure.
Your Lordship, I request for some amount be reduced so that.
40,000 ರೂಪಾಯಿ ಮಾಡಿ.
I request to.
With regard to this, Your Lordship,
Application
already,
ಕೊಟ್ಟಾಯ್ತು
Not quoted, already paid.
ಹಾಕಿದ್ದಾರೆ.
Already on
already is
recording,
married.
but
Your-
one set is not given the orders due to oversight.
ಈ ಅಪ್ಲಿಕೇಶನ್ ಕನ್ಸಿಡರ್ ಮಾಡೋಣ ಮಧ್ಯಾಹ್ನ 40,000 ರೂಪಾಯಿ ಡಿಡಿ ತೊಂಬನಿ.
This is not possible, Your Lordship, because he is out of station, this my.
ನಿಮ್ಮ ಅವ್ರು ಯಾಕೆ ಬರ್ಬೇಕು? ಅವ್ರೇನು ಅದು ದುಡ್ಡು ಹೊತ್ಕೊಂಬರೋದು ಇರ್ತದ?
ಅಲ್ಲ,
ಅವ್ರ ಅಕೌಂಟಿಗೆ ಹಾಕಕ್ಕೆ.
Amount of DD that will be wait, 1 week time be given, Your Lordship, so that we.
ಮಧ್ಯಾಹ್ನ ಕೊಡ್ಬೇಕು.
I request Your Lordship, 2 days, 3 days, we give.
ಅದನ್ನ ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟ್ ಮಾಡೋಣ, ಈಗ ಪೇಮೆಂಟ್ ಮಾಡ್ತೀರಾ?
This is not possible, I am requesting Your Lordship.
ಅದರ್ವೈಸ್ ಐ ಆಮ್ ರಿಜೆಕ್ಟಿಂಗ್ ಯುವರ್ ಅಪ್ಲಿಕೇಶನ್. ಎಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದದು ಆರ್ಡರ್.
Your Lordship, I am requesting, lastly, 2 days time be given, Your Lordship.
ಕೋವಿಡ್ ಟೈಮ್ ನಲ್ಲಿ ಮಗು ಮತ್ತು ಮನೆಯವರಲ್ಲಿ ಇದ್ದಾಗ
Prepared, Your Lordship.
if you are going to pay the amount, otherwise you will strike off your defense. We will not permit you to speak at all. 40,000 ರೂಪಾಯಿ ಕೊಡಿ. Correct. This court-wide order dated so and so had directed payment of rupees 50,000 by way of litigation expenses. First up, the respondent husband has moved an application seeking recall of the said order and in the alternative to modify the same, downsizing the amount ordered. First, some cause is shown in the accompanying affidavit. Negative.
I'll give it. One more
Gala.
submission. One,
Put the respondent is put to warning that in the absence of non-compliance of the order for payment of litigation expenses, comma, all his defense should be struck off, including the pleadings in the court below.
one more submission.
Ah.
It may kindly be noted that I have made oral objection for this application.
Oral? You have object-
Oral objection for this
Counsel
application.
for the appellant wife vehemently opposes the application on sentence Hakabek.
Obliged.
She is afraid of her claim.
It's a legal aid case, Your Lordship, that's why.
That's all. After 2 weeks.
Against this order, my lord, interim order.
In the before sunset of the day, 3 days, 4 days. Within 4 days. Call after 2 days.
See, the violation of the interim order passed by the relevant single judge at annexure G, my lord.
Annexure G.
G, my lord, page number 27. Relevant single judge has stayed the, my lord, transfer order passed by the first accused. In para number 2, my lord, page number 28. Yes.
Stay ಆಗಿದೆ.
Well, after passing this order, my lord,
After this,
I have
he
made
filed
represent.
a application for vacating. The contesting respondent moved the application for vacating. That was rejected by the learned single judge on 5th August 2024. Against that order, my lord, he filed a writ appeal before this court. My lord has pleased to stay the orders.
Order is stayed.
This,
Stay ಆಗಿದೆ.
stay there, but my contention is, my lord, but post this matter along with.
Respondent, if GA appearing for the respondent notifies to the court that the interim order, which is, whose violation is complained of, having been put in a challenge in writ appeal number so and so, has been stayed by this bench. First stop. There is no reason to doubt this version. First stop. In view of this complaint is dropped with liberty to seek its revival on moving a simple memo depending upon outcome of the appeal.
This order has not
Ordered
been
according
challenged. This order complaint in this complaint has not been challenged, my lord. Only, my lord, vacating stay order has been challenged.
Huh?
This order has not been challenged by the, my lord, third respondent in the writ
No,
petition.
he
Other-
made an application seeking vacating of the order.
That has
That
been.
application is rejected. Therefore, there is some interim order by the
Yes,
bench.
there is,
Remember now.
there is an interim order, my lord.
My lord has.
At the relevant point of time, at the.
Revive ಮಾಡಿ ಅದಾದ್ಮೇಲೆ.
Please, my lord, I appear for appellants in this matter, my lord.
Huh?
I filed a memo for withdrawal of the appeal as well as MC, my lord.
Memo seeking leave application.
Application,
In I
sorry.
number 2 of 2024, supported by an affidavit, seeks leave of the court to withdraw the appeal.
Please.
Full stop. Learned counsel appearing for the respondents does not oppose request for leave. First. Next one. In view of the above, appeal is dismissed as having been withdrawn with no liberty to revive or to take other steps for its revival.
My lords, I have sought for withdrawal of even MC of,
MC also.
please, my lord.
Permit the MC. Huh? Yes. Lord. Application in I number 2 of, recall that order. Application in I number 2 of 2024, supported by an affidavit, seeks leave of the court to withdraw the appeal and the case from which the appeal arose. First, such a request can be made in terms of order 23, rule 1, na? 3, no? 3. Rule 3, na? FE. Rule 3 of CPC 1908 as held by Allahabad High Court. ಅಲ್ಲಿ ಯಾವ್ದು ಜಡ್ಜ್ಮೆಂಟ್ ತಗೊಂಡು ಅಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡ್ಬೇಕು.
Please.
Learned counsel appearing for the respondent spouse does not oppose grant of leave as sought for. First, the apex court in Sheila Barse versus so and so has held that right to institute proceedings ordinarily would include right to withdraw the same, subject to all just exceptions into which argued case of the appellant does not fit. First, in view of the above, leave having been granted, the appeal and the original proceedings in MC number
36 of 2021.
Huh?
36 of
30
2021.
of 21 stand dismissed as withdrawn.
My lords, I have sought for liberty, my lords.
What liberty?
My lord, the MC was filed within 6 months of the order of restitution, which is contrary to section 13(1)(a), clause 2.
Liberty to seek
Liberty is concerned, my lord.
ಕೊಡಬೇಕಾಗ್ತದೆ. ಅದು ವಿದಿನ್ ಸ್ಟಿಪ್ಯುಲೇಟೆಡ್ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದಾಗ ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Stipulated period from the date of section 9 application.
Anyway, that liberty has to be accorded. It's a MC matter.
Liberty, my objection may be noted because on the same cause of action, they cannot file.
As sought for. With liberty, as sought. Liberty is always with respect to some cause of action. If it is a different cause of action, where is the question of liberty?
Different cause of action, and
Question
on the same, not on the same cause of action.
Anyway, ಅಲ್ಲಿ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಮೇಲೆ ಬರೀ ಅಲ್ಲಿ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ಹೇಳಿದ್ರು KL ಪಾಟೀಲ್ ಅಲ್ಲಿ ಸೆಂಟೆನ್ಸ್ ಬೇರೆ ಮಾಡ್ಕೋಬೇಕು. Learned counsel appearing for the respondents, although has no objection for granting leave to withdraw, comma, has some reservation for granting liberty to reinstitute the proceedings on the same cause of action. ಅದನ್ನ ರೀತಿ ಮಾಡಬೇಕು. Next, having heard learned counsel for the parties and having perused the appeal papers, we are of the considered view that leave needs to be granted for withdrawing the original proceedings in MC number 36 of 2021, as also the appeal at our hands, with liberty as sought for. First, ordered accordingly.
Grateful.
Connected appeal ನಾಗ ಏನಾಗ್ತದೆ ಅದು ಹೋಗ್ಬಿಡ್ತದೇನೋ.
Connected appeal
ಇದು ಹೋದ್ರೆ
now withdraw ಮಾಡೋದು.
ಈಗ ನಾವು if this goes, original proceedings have gone, the appeal also goes.
ಆ appeal ಇರೋದು on restitution order.
ಅದು restitution
Order ಮೇಲೆ ಬಂದಿದೆ. That
separate ನೀವು ಹಾಕಿದಂತದ್ದು ಅದು ಉಳಿತದೆ.
focus. I will advise my client to withdraw that also subsequent next week.
ಹೇಳ್ಬಿಡ್ತೀನಿ.
Because
ಕೇಳ್ಕೊಂಡು ಹೇಳ್ತೀರಾ?
ಕೇಳ್ಕೊಂಡು ಅವ್ರ ಸೈ ಮಾಡಿಸಿ ಮೆಮೊ ಹಾಕ್ಬಿಡ್ತಾರೆ.
ಕಾಲ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಅದು ಇನ್ನೊಂದಿದೆಯಲ್ಲ.
Great.
My lords, it is under old act, beneficiaries appeal, my lords.
Old act.
Old act, my lords. Main, my lords, it may be ordered.
1 and 2 I accept notice.
1 and 2 state government.
HCGP.
My lords, both IAs and main. Both applications and main mail. And my lords, I seek for interim order. I will deposit the amount, my lords. EP ಹಾಕಿ
ಡೆಪಾಸಿಟ್ ಮಾಡಿಲ್ಲ ಆ ಕಾರಣಕ್ಕೆ ಡೀಮ್ ಟು ಬಿ ವೇಕೇಟೆಡ್ ಹಿಂಗೆಲ್ಲ ಅಲ್ಲ.
ಇಲ್ಲ
ಅಂಡರ್ಟೇಕ್ ಮಾಡಿ.
In all
file an undertaking now.
ಇಲ್ಲ engineer ಇಲ್ಲ, but in all the cases wherever, my lords, in all the cases we have deposited. Enter, please.
Landowners are precipitating the matter by filing the execution. You have the said submission. There shall be interim order of stay of the interim judgment and award of the reference court dated so and so, past in so and so. Next date of hearing, subject to appellant depositing the entire compensation amount, comma, interest, and all the statutory benefits before the reference court within a period of 8 weeks.
8 weeks.
The reference court is directed to redeposit the said amount in any nationalized bank. It's deposited standard order.
Oblige.
All parties.
This case, my lord, my friend has moved an application.
Beautifully conducts the case. Yes.
For, friend has moved an application for vacating stay. Lord, hearing on vacating stay and final hearing. The Jaikumar Patil, my lord, senior counsel is engaged right from the beginning. Lord, he has some inconvenience, my lord, he may be online
Today.
today. From the beginning, my lord, he was there.
My lord, I will state the facts.
ಅಲ್ಲ ಎದಕ್ಕೆ
Lord,
ನಾಳೆ
ಮ್ಯಾಟ್ರ್ ಮುಗಿಸ್ಬೋಣ ನೆಕ್ಸ್ಟ್ 2 weeks ಹಾಕೋಣ ಮ್ಯಾಟ್ರ್ ಮುಗಿಸ್ಬೋಣ
please.
2
Call
weeks,
after.
next week, your lordship.
ಕಾಲ್ ಆಫ್ಟರ್
Next week.
next 2 week after next as requested by counsel for the appellant.
Next week, my lord, may I request?
Next week ಸ್ವಲ್ಪ difficulty ಇದೆ, otherwise you would have taken.
Appellant in some and respondent in some.
Yes,
Representing Budam.
ಮೋಸ್ಟ್ಲಿ ಬರ್ತಿತ್ತು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇರುತ್ತಲ್ಲ 20 19. Yes, Guru.
My lord, this one, we have our
May
appeal, my
concern-
lord, is.
There is one more appeal which has been filed by me. It is posted today. Beneficiary has filed, my lord, the appeal challenging out of the learned single judge, where, my lord, the learned single judge has declined to, my lord, the quash the, my lord, final notification. So only he has quashed the, my lord, only final notification. He has not quashed the April notification.
And
agreed by that, my lord, I have filed an appeal.
That final notification is quashed on what ground?
That we have not considered the objections filed.
Goes to for preliminary notification
Oh,
level.
now
No,
we have
he has-
not considered, it
he has
is
quashed
in
the
not
final
so many
notification.
words.
Inquiry stage ಗೆ ಹೋಗ್ತದೆ ಅದು.
And
ಅಲ್ಲ, preliminary final ಹೋದ್ರೆ unless they have filed objections, if it is quashed on the ground that no opportunity to file objections have been filed or objections are not considered, no objection to file objection idre, Justice Swami says it goes to the level of 4-1 itself so that he can file the objections.
no, I have filed objection.
If you have filed, then it goes to inquiry 5A.
By, my
By
lord,
way
it is under urban development authority, not.
ಅದೇ corresponding
Yes,
provision.
yes, yes. My lord, the
Corresponding provision ಗೆ ಹೋಗುತ್ತೆ.
corresponding was same, my
So
lord.
to that extent, the objection what the learned single judge says, though my lord, I must at the outset say it is not very happily worded what we have said, but it was placed and we have considered the objection and we required this. My lord, this was required for formation of the layout, my lord, for economically weaker sections.
ಅದು ಒಂದೇ ಗ್ರೌಂಡ್ ಮೇಲೆ ಕ್ವಾಶ್ ಮಾಡ್ಯಾರ?
ಅದು ಒಂದೇ ground.
ಗ್ರೌಂಡ್ ಮೇಲೆ ಅದು ಸರಿ ಇಲ್ಲ ಅಂತ ತೋರಿಸಿ ನೋಡೋಣ.
My lord,
ತೋರಿಸಿ ನಿಮ್ಗೆ.
so far as final notification is concerned, I have urged, my lord, the four grounds. Learned judge has not at all considered the four grounds.
ನೋಡೋಣ.
My lord, the
ಮೊದಲಿಗೆ ಇದು ಮಾಡ್ಯಾರ ಅಂತ ತೋರಿಸಿ. ಮುಂದೆ ಅದಕ್ಕೆ ಹೋಗತ್ತಿಲ್ಲ. ಅದನ್ನ
humble
ಮಾಡಿ
submission would be, my lord, request consideration both the appeals.
considering now.
My lord, the.
We are considering.
My lord, the matter may be admitted and, my lord, the.
Not admitted, not necessary. ನೀವು ಹೇಳಿ ನಮ್ಗೆ ಕನ್ವಿನ್ಸ್ ಮಾಡಿ. ನಿಮ್ದು ಇಬ್ಬರದ್ದು ಕೇಸ್ ಕನ್ವಿನ್ಸ್ ಮಾಡಿ ಅವತ್ತು 5 ವರ್ಷ ಇಟ್ಕೊಳ್ಳೋದ್ರಾಗ ಆಗ್ತಿಲ್ಲ ಇಷ್ಟೆಲ್ಲ ಮ್ಯಾಟ್ರಸ್. ತೋರಿಸಿ ವೇರ್ ಇಸ್ ದಿ ಕನ್ಸಿಡರೇಷನ್ ಆಫ್ ದಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್? At least farmers will know where they stand. 91. Annexure H ಅನ್ನೋದು ಅಲ್ಲ R2.
Number 100457.
457.
That is filed by Belgaum Urban Development.
Your roots with Belgaum are still strong. Your roots with Belgaum continue to be stronger.
I was born in Belgaum, mother is.
That's what.
Father from Vijayawada.
Grandfather was a great spiritual hero. Kannur Maharaj, great thinker. Discussion ಆಗಿ ಹೋಗ್ತಿತ್ತು ಹೋದ್ರೆ 5 ನಿಮಿಷದ ಸೋತು. His grandfather was a great spiritual hero.
I didn't know, my lord.
Kannur Maharaj. So many writings, books ಎಲ್ಲ ಇದೆ ಅವರು ಬರೆದು.
ಹೌದಾ, ನನಗೆ ಗೊತ್ತಿಲ್ಲ. This is very simple man.
He is also super. Annexure R2 page 91. ಏನಿದು? ಸರ್ಕಾರದ ಆದೇಶ. ಈ ಆಕ್ಷೇಪಣೆಗಳನ್ನು ಯಾರು ಕನ್ಸಿಡರ್ ಮಾಡಬೇಕು ಅಂಡರ್ ದ ಸ್ಕೀಮ್ ಆಫ್ ದ ಆಕ್ಟ್?
Authority has to consider.
ಯಾವ್ದು ಸೆಕ್ಷನ್ ಹೇಳಿ,
My lord, the
ರೀಡ್ ದ ಸೆಕ್ಷನ್ ಕೊಡಿ. ಇದು ಬೆಂಗಳೂರು ಡೆವಲಪ್ಮೆಂಟ್ ಅಥಾರಿಟೀಸ್ ಆಕ್ಟ್ 87 ಆಕ್ಟ್,
Not the urban development.
87 ಆಕ್ಟ್
Yes, 87 Act, similar to the BD Act,
ಅಲ್ಲ, ಯಾವ ಸೆಕ್ಷನ್?
17.
17. ಓದಿ, ಯಾವ ಸೆಕ್ಷನ್?
17, 18 is the, my lord.
18.
18 would be the approval. 18, sanction of scheme, after publication of the scheme and service of notice as provided in section 17, and after consideration or representation, if any received, in respect thereof, the authority shall submit the scheme.
So authority has to consider it.
Authority.
ಕನ್ಸಿಡರೇಷನ್ ಎಲ್ಲಿದೆ?
That's why at the outset as submitted, my lord, it is not happily.
ಅಲ್ಲ, ಹ್ಯಾಪಿಲಿ ಬೇಡ, ಅನ್ಹ್ಯಾಪಿಲಿ ಹೊಡೆದು ತೋರಿಸಿ.
Lord, I cannot, Lord, I cannot, Lord, my only. Well, understand, Lord, appearing to the land user, Lord, we had formulated a scheme for giving 50% of developed land.
ನಮ್ಗೆ ನೋಡ್ರಿ, ನಮ್ ಒಂದು ಕ್ವಿಂಟಲ್ there is one judgment of apex court where apex court considered Sir Ivor Jennings' views and said no person can be compelled to part away with his property even if a moon is kept at his hands. ಅವ್ರಿಗೆ ಬೇಡಪ್ಪ, ಇದೆಲ್ಲ ಆಗಿತ್ತು ನೋಡ್ರಿ. Where is the consideration? Where is the consideration? That's the consideration. Next.
May I just make one submission? Just before your offer, I'll only make this submission. ಇಲ್ಲಿ ಏನಾಗಿತ್ತು, earlier, my lord, your lordships also are aware in the Swami, they say that when you acquire the land, try to make them a part of it, give them a portion of the land so they retain the land.
That does not, that does not dispense with consideration. No.
Just two submission, then I'll leave it at that. Now,
Your first submission ಹೇಳಿ, ಬರ್ಕೊಳ್ಳಿ. ಅವ್ರ ಫಸ್ಟ್ ಸಬ್ಮಿಷನ್ ಹೇಳ್ಬಿಡಿ, ಅಂದ್ರೆ ಟೈಮ್ ವೇಸ್ಟ್ ಆಗಲ್ಲ. ಅದಕ್ಕೆ ಅದ್ರಾಗೆ ಟೈಮ್ ಹೋಗ್ತು ನಮ್ದು. ಇವೆಲ್ಲ 2 minutes ಕೇಸಸ್ ಎಲ್ಲ ಇದು ತೋರಿಸ್ಬಿಡಿ ನಮ್ಗೆ. ನಾವೇನ್ ಹೇಳ್ತೀವಿ, ಕನ್ಸಿಡರೇಷನ್ ನೀಡ್ ನಾಟ್ ಬಿ ಇನ್ ಡಿಟೇಲ್ ಇನ್ ಸಾಕ್ರೆಟಿಸ್ ಕನ್ಸಿಡರ್ ಮಾಡ್ದಂಗೆ ಮಾಡೋದು ಬೇಕಿಲ್ಲ. We have looked into this. We do not agree with this. ಅದಿಲ್ಲ.
My lord,
ನಿಮ್ದು ಅಪೀಲ್ ಏನು?
my lord, before the learned single judge, I have urged 4 points. My lord, the one is, my lord, there is not delay of 7 years between the preliminary notification and the final notification. That's why, my lord, the final notification has
The
to go.
first ground is still. Kulkarni submits that he had urged 4 grounds before the learned single judge, viz. of 7 years in issuing the final notification.
And the final notification, preliminary notification issued on 28/3/2007.
7 years ಆಗಿರುತ್ತೆ. Next round.
Then, my lord, the authority has to consider objection statement.
Number 2, the authority has not considered the objections filed by 120 persons out of 311.
My lord, no. My lord,
ಬರ್ದಾರಿಲ್ಲ ಅದಕ್ಕೆ.
ಅಲ್ಲ, my lord, there are 2 things. One is, my lord, authority means as defined under section. Authority means chairman and all other members who participated in this one. In this case, my lord, chairman and about, my lord, the 11 members participated in the proceedings. Out of which, my lord, only my lord, the chairman and my lord, and the remaining 3 members signed the, my lord, resolution approving the resolution. Under section 8, it has to be passed by a majority of the decision.
Passed by majority does
Yes.
mean
Yes.
some judgments of the apex court are not signed by the judges.
My lord,
Do you mean to say
no,
they are not judges?
there is a, no, there is a, my lord, the specific clause in the CPC. If a judgment is heard and not signed. That is a different aspect. In this case, my lord, if the resolution has to be passed by majority of the DCs.
How many have signed?
My
How
lord,
many have?
yes, kindly take my lord the,
Mr. Kulkarni,
my lord the,
Mr. Kulkarni.
yes.
Passing a resolution is one thing, signing it or not signing it is
No, no, no.
another. Courts have held that way. You can't say no. I will cite judgment, I will make
My
you
lord,
read it now.
kindly see, my lord, the page number 131, 135 of the writ appeal.
ಅವ್ರೇನು ನೀವು ಕಂಟೆನ್ಷನ್ ಸಬ್ಸ್ಟಾನ್ಶಿಯೇಟ್ ಮಾಡೋದಾಗಿಲ್ಲ, ಅವ್ರೇನೋ ಸಬ್ಸ್ಟಾನ್ಶಿಯೇಟ್ ಮಾಡಂಗ್ ಕಾಣ್ತಾರೆ. ಇಟ್ ಇಸ್ ಕನ್ಸಿಡರ್ಡ್ ರೆಸಲ್ಯೂಷನ್ ಇಸ್ ಪಾಸ್ಟ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಲೆಟ್ ಅಸ್ ಸೀ ದಟ್. ಕೊಡಿ, ಅವ್ರ ಅಪೀಲ್ ಕೊಡಿ.
And ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಅವ್ರಿಗೆ ಒಂದು objection ಹಾಕಿದ್ದು.
23.
They say, I am agreeable for this 50%. That's why I wanted to point out.
Appeal number
What they say in their
474.
objection, that I am agreeable for this 50/50 scheme. However, where land is acquired, you give me 50% there only. So then what happened?
Then the condition is not acceptable.
Yes.
Then it does not amount to consent.
No. Why?
Consent.
I-
It is settled.
Why I am submitting to you for this? ಈಗ 50% ಅಂತಂದ್ರೆ when we form a layout.
Question is not that.
He says in the same piece, his own land only 50% developed.
That means he has objection for acquisition. That's how courts have said now.
Because that is, and in fact, what happened on the earlier occasion, he had said that whether talk of settlement was whether he can leave the house. So my lord, that happened, and we said the house where he is constructed a house, that portion will leave. Then my lord, he said that there is a well a little away, that also you have to leave, my lord, which we said.
Learned senior advocate Mr. Kannur, appearing for the appellant, submits that the impugned order of the learned single judge is to be avoided at least on two principal grounds. Number one, the landowner himself has represented that he would be satisfied if 50% of the land acquired is given back to him in the form of site,
In the same land.
that is in the very same land, and therefore the same amounts to consent for acquisition. Secondly,
That consideration of objection, because at this stage, my lord, we are
but other land. No, Supreme Court said no. Supreme Court said no. It cannot be like that.
But why am I?
If they say yes, it should be unconditional. If they say yes with qualification, it is no consent unless other side is agreeable with that qualification. Angalu Marida. V.G. Ramachandran in land acquisition.
Other convention out of why?
First one is this one. The second one is?
My lord, the second, my lord, that the objections, my lord, have been considered, my lord, but reasons are not forthcoming. But at this stage, my lord, after at this stage, now to remand the matter back, my lord, would.
The objections have been considered by the authority, although such consideration may not be that happy. 3. Notwithstanding lacuna in consideration of the objections, comma, at this length of time, no purpose would be served by remanding the matter to the stage of inquiry, 5A inquiry.
And the other conditions, out of 157 acres which we wanted to acquire, in that, my lord, 106 acres, 23 guttas, my lord, they have consented and they have taken 50%. Then, in respect of another 29 acres, my lord, general award is passed, that is there. Now, only about 18 acres of this are before your lordships. And in this, my lord, I am appearing in this matter where the Kulkarni, my lord, appears, which is 1 acre and 38 gutta. So, my lord, now this has been developed. We have produced, my lord, along with the memo, my lord, the entire sheet where we have formed the sites And why, my lord, we cannot
That was,
give out the land?
that was developed on which date, which time, during what period? During the pendency of the petition?
My lord,
We're asking you. Was it during the pendency of the petition? Not developed.
Nothing has been done. Nothing has been done till today. Nothing.
Even if it has happened, you do it at the risk. ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕು, ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕು, ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಅವ್ರಿಗೆ ಕೇಳ್ಕೊಳ್ಳಿ. ಲ್ಯಾಂಡ್ ಏನು ಡೆವಲಪ್ಮೆಂಟ್ ಮಾಡಿಲ್ಲ. ಮ್ಯಾಪ್ ನೋಡಿದ್ರಿ, ನಾವು ನಿಮ್ಗೆ ಕೇಳ್ತಾ ಇದ್ದೀವಿ, ಡೆವಲಪ್ಮೆಂಟ್ ಆಗಿದೆಯಾ? ಇಲ್ಲ. ನೀವು ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಮ್ಯಾಪ್ ತೋರಿಸಿ ಅಂತೀವಿ. ನಾವು ನಿಮ್ಮ ಮಧ್ಯೆ ಹೋಗ್ತಾ ಇದ್ದೇವೆ ಈಗ, ಮತ್ತೆ ಅದಕ್ಕೆ ಟೈಮ್ ಕಳೆಯಂಗಿಲ್ಲ ನಾವು. ಇದೆರಡೇನ ಮತ್ತೆ ಬೇರೆ ಏನಾರ ಕಂಟೆನ್ಷನ್ ಇದೆಯಾ?
With regard to the delay, my lord, the Land Acquisition Act provision, my lord, will not.
Is not applicable.
Because your lordships are aware.
ಅದು ಆ ಗ್ರೌಂಡ್ ಅನ್ನು ಅವ್ರು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿಲ್ಲ. ಆ ಗ್ರೌಂಡ್ ಅನ್ನೇ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಯಾರ. ಲರ್ನೆಡ್ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಒಂದು ರಿಮೈಂಡೆಡ್ ದ ಮ್ಯಾಟರ್. ಅವ್ರು ಹೇಳಿ ನೋಡೋಣ. ಒಂದೇ ಅವರು 4 ಪಾಯಿಂಟ್ ಹೇಳೋದಿದೆ. ಇದು ನಿಮ್ದು ಆಯ್ತಾ? ಆಯ್ತು, ಕೂತ್ಕೊಳ್ಳಿ. ಪ್ಲೀಸ್ ಬಿ ಸೀಟೆಡ್. ಎಸ್. ಅದು ಅವರು ಅವರ ಅಪೀಲ್.
First ground, my lord,
First ground is delay.
7 years delay in.
Which is the law? What law says?
My lord, the law says there is no time limit has been fixed. But however, I have relied upon the, my lord, the judgments of this honorable court passed in the, my lord, division bench, as well as the, my lord, the Supreme Court judgment, where the, my lord, there is a inordinate delay in filing the, my lord, my lord, I have produced the judgment.
Kulkarni submits 4 grounds in support of his appeal. Number 1, the acquisition is marred by, acquisition process is marred by enormous delay, that is 7 years. And therefore, the same is liable to be voided, notwithstanding absence of prescription of any particular period for accomplishing the process. In support of this, he banks upon decision of apex court in.
My lord, first, my lord, the judgment of our own High Court.
Shivanna.
My lord, yes, Shivanna court. That has been relied upon by the, my lord, the learned single judge.
Shivanna versus so and so, with the learned single judge has relied upon. ಅಲ್ಲಿ ಎಷ್ಟು ಡಿಲೇ ಎಷ್ಟಿತ್ತು?
ಅಲ್ಲಿ 7 years ಆಯ್ತು.
ಏನು ಸರ್ಕಮ್ಸ್ಟೆನ್ಸ್ ಏನಿತ್ತು?
ಅಲ್ಲಿ circumstances, my lord, here also, my lord, the preliminary notification passed in the 2007.
Circumstance ಏನಿತ್ತು?
My lord, may I read the, my lord, the Shivanna judgment? There are 2 judgments are relied upon. One is the, my lord, the Shumaga Urban Development Authority case.
Paragraph?
16. Yes, paragraph 16. These appeals have failed to one more ground. The preliminary notification issued on 22/1/85, published on 7/11/85 of Navale village itself, or included in the Urban Development Authority with effect from 87. The development scheme was approved by the government under 18(3) Authority 1989. The final notification was issued 3 years thereafter, 62. The time gap between the preliminary notification and the final notification as 7 years. Even if the period of the approval of the scheme by the state government excluded, there is a delay of the 3 years. It is no doubt true that neither the improvement board nor the Karnataka authority any time limit for issuing the public and final notification under 19(1). The effect of a delay has been considered by the Supreme Court in the Ramchanda versus Union of India. Those third case dealt with the delay between the date of final notification and the date of passing award. The principle enumerated in there equally applicable to respect to delay between the preliminary notification and final notification following observation or above. It is settled that statute where the exercise power no time limit is fixed. It has to be exercised within that time which can be exercised reasonable. The authority is enjoyed by the statute concerned to perform the duty within the reasonable time, and thus they are answerable to the court why such duties have been performed by the committee. The Supreme Court held where the compensation, that's all we are not. The next case is the my lord Shivanna case.
This is apex court, Karnataka only.
No, Karnataka division bench judgment. This is also my next is a single judge judgment, Shivanna case. My lord, the similar views taken by the learned single judge. My lord, may I read it? My lord, the
ಎಲ್ಲಿದೆ?
yes.
ಶಿವಣ್ಣ ಹಾಕಿಲ್ಲ. ಅಮೀರ್ ಖಾನ್ ಹಾಕಿದೆ.
My lord,
ಶಿವಣ್ಣ ಹಾಕಿಲ್ಲ.
my lord, the
ಕುಮಾರ್ ಸಾಹೇಬ್ ಅವ್ರದ್ದು ಅದು.
Kumar Sahibar.
ಎಲ್ಲಿದೆ?
My lord, they have produced it. My lord, the
ಕೊಟ್ಟಿರಾ?
ಇಲ್ವಾ?
ನಿಮ್ಮತ್ತಿಗಿದೆ ಇನ್ನೊಂದು.
My lord, ಅಂತ ಇದೆ.
ಕಾಪಿ ಕೊಡಿ. ಹೇಳಿ. Correct. But statute does not, but even PTC reasonable time until the Supreme Court.
Para 21. Para 21 and para 22.
And Shivanna's judgment. ಶಿವಣ್ಣ ಸೈಟೇಷನ್ ಹೇಳಿ.
ಮಾಡ್ರಿ ಕೊಟ್ಟಿದ್ದೇನೆ my lord.
ಎಲ್ಲ ರಿಪೋರ್ಟ್ ಆಗಿಲ್ಲ ನೋಡಿ. ಇದು ಅಲ್ಲ ಅದು ಶಿವಣ್ಣ ಅಲ್ಲ. ಶಿವಣ್ಣ ಅವ್ರದ್ದು ಶಿವಣ್ಣ ಜಜ್ಮೆಂಟ್ ಇದೆ. ಜಸ್ಟಿಸ್ ಕುಮಾರ್ ಅವ್ರದ್ದು ಒಂದು ಜಜ್ಮೆಂಟ್.
ಹೌದು ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೇನೆ ಅಲ್ಲಿ ಈಗ ಕೊಟ್ಟಿದ್ದೇನೆ ನೋಡಿ. ನೋಡಿ ಮೆಮ್ ಇಟ್ ಹ್ಯಾಸ್ ಬೀನ್ ಫೈಲ್ಡ್ ಅಲಾಂಗ್ ವಿತ್ ಮೆಮೋ ಆಫ್ ಸೈಟೇಷನ್ my lord.
ಮೆಮೋದಲ್ಲಿ ಶಿವಮೊಗ್ಗ ಸೂಡಾ ವರ್ಸಸ್ ಸ್ಟೇಟ್. ನಂಬರ್ 2 ಈಸ್ ಆಮೀರ್ ಖಾನ್ ವರ್ಸಸ್ ಸ್ಟೇಟ್. ಎರಡೇ ಜಜ್ಮೆಂಟ್. ನಂಬರ್ 3 WP ನಂಬರ್ ಸೊ ಅಬ್ದುಲ್ ರಿಯಾಜ್ ಬಸಾ ವರ್ಸಸ್ ಸ್ಟೇಟ್. ಮೂರನ್ನು ಮಾತ್ರ ಕೊಟ್ಟಿರಿ ನೀವು. ಇದ್ರಾಗೆಲ್ಲ ರೆಫರ್ ಆಗಿದೆಯಾ?
ಮಾಡಿ ಈ ಲರ್ನರ್ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಅಲ್ಲಿ ಇಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ರೆಫರ್ಡ್.
Serial number 3.
In fact, my lord, it was cited and given. It's part of the records of before the learned single judge. Unfortunately, my lord, the learned single judge has not referred those judgments. This was produced before the learned single judge judgments on the, my lord, on 6th August 2021.
ಕಾಪಿ ಇದೆ. ಒಂದು ಎರಡು ಕಾಪಿ ಮಾಡಿ ಯಾವುದು?
Yes.
ಎರಡು ಕಾಪಿ ಮಾಡಿ.
My lord, there are, my lord, the 4 judgments have been produced. Then the next case is for the different purpose. My lord, for so far as the preliminary.
ಏನೋ ಹೇಳೋಕೆ ಮಾಡಿ ಅವ್ರು ಹೇಳಿ ನಿಮ್ಮ ಸೀನಿಯರ್ಗೆ. ಅವ್ರು ಕೇಳ್ತಾ ಇಲ್ಲಲ್ಲ. Since the market value will be determined as on the date of preliminary notification, brooking delay, enormous delay would affect your right ಅನ್ನೋ reasoning ಮೇಲೆ ಮಾಡಿದ್ದಾರೆ.
No, ಅದಕ್ಕೆ ನಾನು ಇನ್ನೊಂದು ಹೇಳ್ತೇನೆ. That is why the reason. In the pendency of the 7 years, my lord, all the agriculturists except the petitioners, my lord, they thought, my lord, the acquisition has been abandoned. On that presumption, most of the buildings have been come, development has been taken place, and my lord, the urban development authority, my lord, has given a permission for the most of the, my lord, the landowners to construct the building. My lord, the Gokakar, my lord, appearing for, he will say all those things. And my lord,
ನಿಮ್ದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಹೇಳ್ರಿ.
ನಮ್ಮಲ್ಲಿ ಏನ್ ಮಾಡಿಲ್ಲ.
ಬಿಡಿ.
No. But now lordship says, my lord, since my lord,
abandon ಮಾಡಿದ್ದಾರೆ ಈ ಡೆವಲಪ್ಮೆಂಟ್.
it means
whole scheme will lapse ಅಂತ.
Scheme will lapse ಅಂತಲ್ಲ. My lord, if they, my lord, they have to take an action within a reasonable period of time. If they don't take an action within the reasonable time, no, they deemed to have abandoned the, my lord, to formation of the scheme.
ಆ ಗ್ರೌಂಡ್ ಇಲ್ಲಿ ತಗೊಂಡಿರಿ.
My lord, that is the,
ತೋರಿಸಿ.
my lord, that is the, my lord, I have relied upon section the judgment.
ಜಜ್ಮೆಂಟ್ ಪ್ರಶ್ನೆ ಯಾವಾಗ ಬರ್ತದೆ? ಆ ಗ್ರೌಂಡ್ ತಗೊಂಡಿರ್ಬೇಕು ನಿಮ್ಮ ಪಿಟಿಷನ್ ದಲ್ಲಿ. ತೋರಿಸಿ.
Yes, my lord, my lord, I have taken as an additional ground in a writ petition.
ತಗೊಂಡಿರಾ? ಅಬೆಂಡನ್ಮೆಂಟ್ ಆಗಿದೆ ಅಥವಾ ಇನ್ಎಕ್ಸಿಕ್ಯೂಟಲ್ ಆಗಿದೆ ಸ್ಕೀಮ್ ತೋರಿಸಿ. ವೇರ್ ಹ್ಯಾವ್ ಪ್ಲೀಡೆಡ್?
Regarding didn't on complaints of lapsing folder.
5 years is after the 5 years time of application.
My lord, specifically it has not been taken, but my lord, in the, my lord, effect of the, my lord, the judgment of the, my lord, the two judgments you have been, if the, my lord, the action is not taken within the reasonable time, no, my lord, it is a question of law. It need not be taken as a ground. Yes, my lord.
Law operates in vacuum.
No, my lord, they have issued a preliminary notification in the year 2007, and my lord, the final notification in the 2014. My lord, the law says, if a, my lord, action is not taken by any authority within a reasonable time, they deem to have been abandoned their right to issue a final notification. That is a settled question of law.
Law is settled.
My lord, and another fact is, my lord, they have not developed the land till today. No.
ನೋಡಿ ಒಂದೊಂದ ಹೋಗೋಣ ಮೆಥಡಿಕ್ ಆಗಿ.
Yes, yes.
ನಾವು the contention Mr. Kulkarni submits that scheme, the acquisition process itself has been abandoned. Semicolon. When we asked him to show whether this ground is taken up in his pleadings, comma, he is not in a position to satisfy us. Therefore, this contention we will not consider, whatever be the legal position. So, the lapsing one the birthday.
No, lapsing, my lord, the underground has said, since, my lord, after preliminary notification and also final notification, my lord, they have not taken to develop the land. Till today, it is a vacant land. Under these conditions, it has to be treated as abandoned.
ಅಂತ ಕಂಟೆನ್ಷನ್ ತಗೋಬೇಕು.
My lord, that is the factual aspect, my lord.
ಅದಕ್ಕೆ ಕಂಟೆನ್ಷನ್ ತಗೋಬೇಕು. ಫ್ಯಾಕ್ಚುಯಲ್ ಆಸ್ಪೆಕ್ಟ್ ಇರೋದು ಕಂಟೆನ್ಷನ್ ತಗೋಬೇಕು. ಲೀಗಲ್ ಆಸ್ಪೆಕ್ಟ್ ಇದ್ರೆ ತಗೊಳ್ಳೋ ಅಗತ್ಯ ಇಲ್ಲ. ಎನಿವೇರ್ ಯು ಕ್ಯಾನ್ ಅರ್ಚ್.
Oh no, that's why I said, my lord,
next point. ಆಯ್ತಾ ಬೇರೆ ಇದೆಯಾ ಏನಾದ್ರು?
This ground, my lord, it is not developed and it has to be, my lord, till today. No, my lord, the activity has taken place. It is deemed to have abandoned. And
that now you have already said. You have said
that
it
has
twice.
been, my lord,
we have understood. Go to the next point.
My lord, so far during the pendency of the case, my lord, after issuing a notification, the Urban Development Authority has issued a no objection certificate, and also they have issued a, my lord, the denotifying the certain lands.
Denotification ಇದೆಯಾ?
My lord, Gokakar has produced all those documents in his cases, and he has urged it in all those cases also. My lord, he will highlight about all those things. My lord, I have not taken those grounds, and he will highlight it. Then, my lord,
Para 16 ದಲ್ಲಿ
ಹೇಳಿದೆ
ಅದು that does not satisfy us. We have seen that. Para 16 we have read.
Abandoned ante word is not specifically used, but what we have said,
meaning ಬರೋದು ಇಲ್ಲ.
it indicates that the land is
anta
what specifically stated is, it indicates that the Buddha is not in requirement of the land.
ಅದು ಹೇಳಿದ್ದೇವೆ. The petitioner submitted the preliminary notification.
it does not require land is much different from, it has abandoned the acquisition process. Ariti V.G. Ramachandran says in his book. Next point.
My lord, I will read it, para 16.
Twice have we read to help you.
For
But
my
we could not-
satisfaction, my
You
lord.
can read it in your mind. We cannot go on reading again and again.
No,
Yes, next. Go
I
to
have not
please.
read it, my lord, that's
Hello,
all.
we have read that.
Yes, my
Now
lord.
indicate material.
Yes.
We
my-
indicated to you. Yes.
Then, my lord, the next contention is, my lord, under the act, the objections have to be considered by authority.
That
What
has not happened.
My lord?
That has not happened is your contention.
Yes, my lord.
Authority means all of them.
Yes,
They
kindly
should
see the
put the
definition.
signature.
No, kindly see the definition, my lord, of the authority.
Notice you know.
Yes,
We have seen that now.
yes,
You can go further.
yes.
We have considered that. We have written a reportable judgment on that. What is meant by authority?
Then, my lord, I have to substantiate that case, I have relied upon the judgment of this honorable court. What is authority? My lord, kindly see the, my lord, what is authority means, my lord, kindly take the judgment of the, my lord, but Justice Vishwanath Shetty judgment, my lord, uh,
Amir Khan.
Amir Khan, yes. My lord,
There are 12. 12 what?
paragraph,
12.
yes, paragraph 12.
Yes.
Then if you are, is it necessary to me read the, my lord, paragraph 12? I find a considerable in the force and submission of the counsel for the petitioner representation. Petitioner file petitioners have not been considered authority in terms of section so and so other act. Annexed R1 produced by the second respondent show. Commissioner of the second respondent authority objection filed by the petitioner and the landowners. He also heard the counsel for appearing some of the objection. In my view, mandates authority is to consider representation objector. Scheme in the
Submits. The consideration of the objections means the consideration at the hands of the authority. First, in support of this, he loudly reads out para 12 of Amir.
Yes,
Amir
but in this
Khan,
case, my lord, out of the, kindly see, my lord, the resolution.
2000. Amir Khan. This is state of Karnataka. Bracketnalli, PVSJ. Next part.
My lord,
To substantiate his claim, he takes us through.
my lord, the resolution copy which has been produced by the respondent. First the resolution, my lord, they have produced annexure R2, page number 80. My paper book, my lord.
Nimda? 474.
Page number 80. My lord, idರಲ್ಲಿ it has been signed by the chairman and the, my lord, commissioner. Ibre. Then, my lord, they produce the, my lord, I got my own doubt of the produce the entire resolution copy, wide annexure.
ನಮ್ಗೆ ಓದ್ಲಿಕ್ಕೆ ಹೇಳಿರಿ ನೀವು ನಾವು ಓದ್ಬೇಕಲ್ಲ
ಅಲ್ಲ
ಏನ್ ಬೇಡ ಬೇಡ
ಅಲ್ಲ ಇಬ್ಬರೇ ಸೈನ್ ಮಾಡಿದಾರಂತ ಅಷ್ಟೇ, ಮತ್ತೇನಿಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನಿಲ್ಲ.
Kannur. Delhi authority will consider.
Attendance register is there where all the members are present. And if your lordship sees section 8,
3.
meeting of the authority.
My lord,
The meeting of the authority shall be convened by the chairman and secretary of the authority.
Section 3.
The authority shall meet at such.
3 subsection. Authority shall consist of the following. Subsection 3 ಬನ್ನಿ.
Consist of so and so, that your lordship are seeing constitution and incorporation of the authority.
ಇವರೆಲ್ಲ ಸೇರ್ಕೊಂಡು ಅಥಾರಿಟಿ ಆಗ್ತದೆ. ಇವರೆಲ್ಲ ಸೇರ್ಕೊಂಡು ಅಥಾರಿಟಿ. Collectively, they are called as authority. And authority is a legal person. That's how we have held.
Attendance register, my lord, shows that they were present. In the meeting of the authority, this, in my view, subject to what your lordships have to say, does not say, my lord, that all of them have to sign. Subject to what your lordships have to say. In my view, that this, my lord, section 8, my lord, does not say that it has to be signed by all the members. But because on that ground, my lord, the resolution cannot go, my lord, because the commissioner and chairman.
But how the proceedings are taken up under which rules? Rule 7. Otherwise, majority decision ಆಗಬೇಕಾಗ್ತದೆ. ಅದ್ ಹೆಂಗೆ ಅಸರ್ಟನ್ ಮಾಡೋದು ಹೆಂಗೆ?
ಅಲ್ಲ, ಈಗ I'll just read this.
ಪ್ರೊಸೀಡಿಂಗ್ ರೂಲ್ಸ್ ಇಲ್ವಾ? ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ರೂಲ್ಸ್ ಇಲ್ಲ ನೋಡ್ರಿ. ಇದು ಕೂಡ ಕೆಳಗಡೆ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಆಫ್ ಬಿಸಿನೆಸ್ ರೂಲ್ಸ್ ಅಥವಾ ರೂಲ್ಸ್ ಏನೇನಿದೆ ನೋಡಿ. ಡೋಂಟ್ ಗೋ ಬೈ ದೇರ್ ವರ್ಷನ್. Meeting of the authority by the chairman shall be held in any place within so and so shall meet. Such rules and procedures in certain transactions of business at the meetings, these shall be at least one meeting. This shall be transacted at any meeting unless half of the number of total members are present. They are present to
Lord may see page 146 annexure R16.
ಬರೋಣ ಹೋಗೋಣ ಫ್ಯಾಕ್ಟ್ಸಿಗೆ ಹೋಗೋಣ. ನನ್ಗೆ ಡೌಟ್ ಇದೆ ಇವ್ರ ವರ್ಷನ್ ಅಲ್ಲಿ ನೋಡಿ. ರೂಲ್ ಸಬ್ ರೂಲ್ ಸಬ್ಸೆಕ್ಷನ್ 4 of 3 subsection 4 of 3 the person referred section 8 you are right. Section 80 bani. What Kulkarni says appears to be sensible. Go to section 8.
The meeting of the authority shall be convened by the chairman and shall be held at any place within the jurisdiction of the authority.
Correct.
The authority shall meet at such time and shall observe such rules of procedure in regard to the transaction of business.
Al transaction of business rules irrelevant.
There shall be at least one meeting in a month. No business shall be transacted at any meeting unless
half of the number of total numbers are present.
That they are
present meeting resolution aglikke idu to hold meeting. The first requirement is minimum 50% of the members should be present personally. Then what they will do adar mele iddare alli ellaru iddirbodu amat bere what they have done.
The chairman or for any reason is unable to attend any meeting.
He can
or any member chosen by the members present at the meeting shall preside at the meeting.
Correct.
Now 4, all questions which come up before any meeting of the authority
by a majority of votes
of the members
present
and in the event of an equality of votes the chairman
ಆ ಪ್ರಶ್ನೆಗೆ ಬರಲ್ಲ ಅಲ್ಲಿಗೆ ಹೋಗೋದಿಲ್ಲ. Majority of votes of persons present and voting ಆಗಿತ್ತು ಸರ್. ಪ್ರೆಸೆಂಟ್ ಇದ್ರೆ ನೀವು ಹೇಳೋದು ಒಪ್ಪಿಡ್ತಿದ್ವಿ ನಾವು. ವೋಟಿಂಗ್ ಅನ್ನೋ ವರ್ಡ್ ಇದೆ ಇಲ್ಲಿ ಮುಂದೆ.
Proceeding sheet, my lord, now what we have produced, my lord, what your lordships are asking, my lord, that voting there we don't have a document.
ಮತ್ತೆ ಮೆಜಾರಿಟಿ ಆಗಿದೆ ಅಂತ ಗೊತ್ತಾಗೋದು ಹೆಂಗೆ ನಮಗೆ? ಇವೆಲ್ಲ ಸೇಫ್ ಗಾರ್ಡ್ಸ್.
This would show. I am only submitting this annexure R16 page 146 your lordship.
ಅಲ್ಲ ಇದರ ಅರ್ಥ ಹೇಳಿ. So tell us how do you understand this? What way you have understood it?
My lord,
forget this case. Forget this case.
It is generally what it means.
Two things are present.
Members present and voting.
There should be 50% of the members should, at least 50% should be present. Present in the voter because you have produced the attendance register. We'll assume that they were present. And voting. You can't kill any word employed in a statute. You have to give meaning to every word in the statute. So present and voting ante yaake beku andre whether it is majority decision or not, ಅಥವಾ ಇವರಿಬ್ಬರೇ ಚೇರ್ಮನ್ ಕಮಿಷನರ್ ಇಬ್ಬರೇ ಸೇರ್ಕೊಂಡು ಎಲ್ಲ ಮಾಡಿಬಿಟ್ರೆ ಅಥಾರಿಟಿ ಆಗಲ್ಲ.
My lord, I accept that. But if, my lord, there are two things. One, if there are, whether there are majority and if there is subsection 2 of section 8 or 4. Lord, if it is a case where, my lord, the number of members as mentioned are not present.
No, we are present. We are present now.
So, my lord, if that is taken, then, my lord, now once, my lord, it has been signed, now can it be said, my lord, that.
Signed by whom?
Not by my lord, the responsible people, my lord, the.
We do not know. They are responsible, irresponsible. We do not know. We don't hold such an inquiry. We want to know. He says, these are in the wisdom of the legislature. ನೀವೇನೇ ಮಾಡೋದಿದ್ರು ಈ ರೀತಿ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿದೆ ಅದು. We are bound by law. We are not the lawmakers. We are only coordinate branch of the state.
Ultimately, your lordships also would interpret it in a way which would, my lord,
help you.
My lord, I get, my lord, this is ultimately how it interpret.
Right to property, constitutional guarantee ಅದು. Constitutional 300A ಹೆಂಗ್ ಓದ್ತದ ನೋಡಿ, ಅಲ್ಲಿ ವರ್ಡ್ ಕಾಂಪನ್ಸೇಷನ್ ಅಂತ ಇಲ್ಲ. Except in accordance with law.
Why?
Due process of law ಬೇಕಾಗತ್ತೆ.
What I am saying is, if your lordships looks at the entire matter, my lord, ultimately a holistic approach, and your lordship sees the entire thing, my lord, in totality, then your lord, my lord, like on somewhere, my lord, in some small thing, my lord, to.
What is this small thing?
No, I'm not saying that, my lord. All that I'm saying is, my lord.
What you say is ignore subsection 4 because 2 is satisfied, 3 is satisfied. You ignore 4 and see the whole picture. Seeing whole picture means entire thing has to be seen. ನಿಮ್ಮ ಅನೆಕ್ಸರ್ ಯಾವ್ದಿದೆ ರೀ? ಅವ್ರು ವೋಟ್ ಮಾಡ್ಯಾರ ಅಂತ ತೋರಿಸಿ ಅವ್ರು ಹೇಳೋದು ಅದನ್ನೇ. ನಮ್ಗೆ ಅದೆಲ್ಲ ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರ ಅಥಾರಿಟಿ ಅಲ್ಲ ಅಂತಾರೆ. ಅದಕ್ಕೆ ನಾವು ಉತ್ತರ ಕೊಡೋದು ಹೆಂಗೆ? ನಮಗ್ ತೋರಿಸಿ. ಇಲ್ಲ ಹೋಗತ್ತೆ ಮೆಜಾರಿಟಿ. ಅದರ್ವೈಸ್ ಇಟ್ ಬಿಕಮ್ಸ್ ಡೆಮಾಕ್ರೆಟಿಕ್ ಪ್ರೊಸೆಸ್ ಇದೆ.
My lord, now what I can, my lord, as appearing for Buddha, how I justify, my lord, the acquisition. My lord, ultimately your lordships will interpret and my lord, your lordships will pass out. But like I, my lord,
Kulkarni submits that in terms of section, the provisions of section 10 of the 1987 Act, the authority has to consider the objections filed by the landowners to the proposal for acquisition. And he draws our attention to section 3. 3A, 2A, read with section 3 of the Act to impress us that the authority includes as many as A, B, 1, 2, 3, 4, 5, 6, 7, 8, 9, 14, as many as 14 persons, 14 officials, and that any decision of the authority has to be by members not less than 50% in all present, and further voting by majority. First, this has not happened. First, in support of this, he draws our attention to Annexure R2 dated 7/1/2010, which mentions of meeting of the authority And only it bears the signature of commissioner and the chairman of Buddha. First, it does not say anything about how many members were present, how the discussion took place, and how many of them have put their subscribed their hands to the same. First, next. In support of this, he banks upon para 16 of Amir Khan. Amir Khan. Next one. Learned senior counsel, Mr. Kannur, appearing for the authority, draws our attention to
Lord, annexure R15, page 144.
annexure R15,
Page 144,
bracket null 144,
the attendance register.
which shows, which is an attendance register, which shows how many members were present on the said day. First. ಎಷ್ಟು ಜನರನ್ನು ತೋರಿಸ್ತದೆ?
13.
10, 10.
And then.
No, no.
All right, 10 ಇದ್ರು 50% ಆಯ್ತು. Where is the voting?
I'll only make my submission for that. My submission to your lordship says.
It shows, prima facie shows that 10 of 16 members.
But present and have signed.
14 members, madam.
14 members were present. ಮುಂದಿನ sentence? Signed. Present and signed.
Signed the attendance.
Attendance register. And they have marked their attendance. Additionally.
And my lord, approved by 4 members. No.
My submission would be this. That when they are present and they have signed.
It's over. Everything is resolved.
I would, my lord, say that when the responsible officer.
Present and signed to what? Signed to what?
For the meeting which has taken place, and in that meeting this resolution has been passed.
They'll sign
They
again.
are part of that. They are part of the, this cannot be disputed that they were not part of the meeting, but they are present. However, as your lordships are saying, voting has taken place.
Majority ಆಗ್ಬೇಕಲ್ಲ.
ಅಲ್ಲ, majority ಇದ್ದಾರೆ.
ಇಷ್ಟು ಜನ ಪ್ರೆಸೆಂಟ್ ಇದ್ರು,
Majority are there.
ಅದರಲ್ಲಿ ಇಷ್ಟು ಜನ ಒಪ್ಪಿದ್ರು, ಇಷ್ಟು ಜನ ಒಪ್ಪಲಿಲ್ಲ, ಇಷ್ಟು ಜನ ಅಬ್ಸೆಂಟ್ ಇದ್ದಾರೆ. ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಡ್ರಾ ಆಗಬೇಕಲ್ಲ.
I can, my lord.
ಅಲ್ಲ, you convince us. Somehow we want to extract something from you.
Yes, now I can, Lord, what I cannot, Lord,
Improve that is true.
Lord, I cannot, Lord, now all that I can only try to say, Lord, I can only try to justify this by saying, Lord, ultimately the entire object of this is when the committee meets, and if, Lord, if there were any objection, it would have been known. There are no objections. Majority of the members are present. They have signed the register. Lord, this in my view,
ಯಾವ ರಿಜಿಸ್ಟರ್ ಅದು?
attendance register. So that, Lord, this one.
ಅದನ್ನು ಹೇಳ್ಬೇಕು. You have to be fair because you are appearing for a
Yes.
Statutory
Lord,
body.
attendance register. That's all I'm saying.
He says, Mr. Kannur says, the members signing the attendance register at page 144 in his writ appeal amounts to members signing the resolution, and therefore it should be presumed that the resolution is passed by all the signatories.
Because this section, subsection 4 of section 8 does not say that all of them have to sign. Voting, as your lordships have rightly said, Lord, that I do accept. But it does not say that all of them have to sign. Now, once, my lord, as your lordship said, my contention is this: they are present. This
Section, the provisions of section 10 do not require signatures being put by each of the participants in the meeting to the resolution. Okay.
And since the responsible officers have signed, this would indicate that it's on the.
Since the responsible officials have signed the resolution,
Chairman and the commissioner.
that is chairman and the commissioner, come on, it should be presumed that the resolution has been duly passed. Okay.
Now, my lord, with regard to delay, Lord, two submissions. One, as your lordships are aware, my lord, 11A, my lord, would not be applicable to BD Act and to the Urban Development Act because, my lord, they are.
Correct, we know all that. Go further. These are all well-established things, yes.
So, my lord, the question of abandonment will also not come.
No, delay is different, abandonment is different.
The lapsing will not come. Lapsing will not happen because for lapsing under either the BD Act or under the Urban Development Act, my lord, substantial.
Lapsing also they are not, they are only saying 7 years delay. 7 years delay there.
But that we have given the reasons as to why there was.
Yes, what is that?
Said as to how, if you want to see the additional statement of objection, we have produced all the, my lord, the communication between the authority and the government.
Where have you taken up the explanation for the delay? ನಿಮ್ಮ objection ದಲ್ಲಿ ಎಲ್ಲಿದೆ? ಯಾವ paragraph? Four nine, 418. Page number 230.
This affidavit was filed when the court posed a question at the time of argument. Thereafter, they have explained the delay. Till then, they were not at all diligent.
Page number?
This is the objections filed before the learned single judge. Learned single judge, what has been filed, it starts from para 4. Para 4.
238, additional statement of objection. In the first statement of objection was filed when?
That was filed on.
Page number in.
Page number
7/12/2018.
is the last page.
It was filed on 7/12/2018.
2018.
First statement of objection.
Mr. Kannur submits that the statement of objections was filed on
12/2018.
12/2018. First up. Mr. Kulkarni submits that in that statement of objections, there is no explanation for the delay of 7 years brooked in the acquisition process. First up. Mr. Kannur draws our attention to additional statement of objections filed on 9/8/2021 at page 3232 on Beko, wherein paragraph.
No, it starts from paragraph 4. Virtually explaining the delay totally not as to why it took place.
Paragraph 4 ಇರೋದೇ 3 ಪ್ಯಾರಾ ಇದೆ.
Para 4.
ಅಡಿಷನಲ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ 3 ಪ್ಯಾರಾಗ್ರಾಫ್ ಇದೆ. 232 ಮತ್ತೊಂದು ಅಡಿಷನಲ್ ಇದೆ.
12/12 ಹಾಕಿದ್ದಾರೆ.
All these documents have been produced.
Next.
In the said additional statement of objections, nothing is mentioned about the delay. Then Mr. Kannur draws our attention to yet another statement of objections filed on 12/12/2022, wherein paragraph 4 mentions about the circumstances that resulted into brooking of delay.
My lord, let him read this one.
Read.
Yes, yes, my lord.
Pertinent to know that as per the revised CDP, the land measuring 27 acre 23 gutas included in the scheme 61 was earmarked for open space, public and semi-public use. Hence, it was resolved to submit the proposal to the respondent for one government for issuance of order of change of land use for residential purpose. Accordingly, the respondent submitted the proposal to government with a office letter.
One second, which is the date of preliminary notification date, you know?
12/4/2007.
12/4/2007. All right. When did you submit to the government your proposal for conversion of land? They have stated.
24/9/2010.
No, it's a
proposal to the government, video office letter dated 24/9/2010,
Oh.
at annexure R39.
All right. What about, the date is 2007. What happened to these 3 years?
No explanation.
3 years ಏನಿದೆ ಇದು ಸೆಪ್ಟೆಂಬರ್ 2010 ಇಂದ ಮುಂದಿನ ಏನೇನಾಯ್ತು ಅಂತ ಬಂತು. ಈ 3 years ಏನಾಗಿದೆ ಅಂತ. Though delay of each day need not be explained, given under section. We are asking.
In Shivram Karan, the Honorable Supreme Court, my lord, that considering Shivanna's case, my lord, there they have gone to the extent that if the authority have not gone forward, my lord, the Supreme Court has directed, my lord, the authority to issue a final notification.
ಅದು ಅವ್ರು
But
ಮಾಡೋದು.
that the Supreme Court, my lord, has done that, and then in fact,
ಅದು 142.
the Deshunaran committee was appointed.
142 ಕೆಳಗೆ ಮಾಡಿದ್ದೇವೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸಬ್ಸೆಕ್ವೆಂಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಇದೆ. Because I am part of the bench. I am part of Shivram Karanta layout bench. Yes, therefore take my words as final. Otherwise we will produce that order. To contradict your version, it was under 142. Supreme Court has said it in one judgment. 142 ಇದ್ದಾಗ 141 ಆಗಲ್ಲ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ. Next point.
So, my lord, now this, the delay, my lord, of, now, the first submission is, my lord, that there is no time prescribed.
You have said that, yes.
Secondly, my lord, that we have explained the delay. My lord, because here also, if your lordship sees, there it is 2 years, now here it is 3 years. Beyond 3 years, my lord, then again there is explanation till the, my lord, the final notification. Because, my lord, we also came up with a benevolent scheme. First, my lord, we had said 40/60. Then we said we'll give 50/50.
ಅಲ್ಲ ಡಿಲೇ ಮೇಲೆ ಮಾತಾಡಿ ಆಮೇಲೆ ಮುಂದಕ್ಕೆ ಹೋಗಿ.
Delay the help.
ಇಷ್ಟೇ ಆಯ್ತಾ?
This is all that. So this is how we have approached the government, where, my lord, we said it will be more beneficial. That, my lord, the Honorable Supreme Court has said that giving 40% is more beneficial to the.
Now delay part is over. The delay part is over now.
I am saying that for the reason, from 40% we have made it to 50%. For that, we have to again take the approval of the government. So I am trying to say that we have done something more for, by issuing the final notification, we have done something more for them, for the land losers. So that is the reason why it has taken delay. It is not that we are trying to, my lord, shirk from the responsibility.
Para 4, which is loudly read out by the learned senior advocate, is militantly absent as to 3 years brooked between issuance of preliminary notification and submission of the proposal to the government on 24/9/2010 for issuance an order for change of land use for residential purpose.
But can now, my lord, be held that in respect, my lord, now it is settled principle of law that it cannot be said that in respect of a portion of land it has lapsed. My lord, the entire thing has to be taken if there is substantial compliance, if there is, we have implementation substantial.
We are not on lapsing at all.
Actually, we are not on the lapse.
We are on ground of delay is different.
So what happens if there is a delay? Ultimately, what is their prayer, my lord? I ask myself.
Now we will tell you. Delay and laches is one thing. Abandonment is another. Lapse of proceedings is at another. Lapse is spoken of under section 11 capital A.
That is under the, this is under the BDI.
That is lapsing of acquisition proceeding. That is unknown to this law, 1987 Act. Lapsing of scheme is another. We will come to that one now. One by one we will treat methodically. So on delay, this is your explanation. Then go to the next point.
And the other thing also is, my lord, even if the scheme lapses, the acquisition will not lapse. That also is, my lord, now it is a principle of law. My lord, that the judgments are there. I don't have that right now, but that is there. That scheme may lapse, my lord, but the acquisition will not. So once the land is vested, my lord, then the question of divesting will not, my lord, will not arise at all. Once the land is vested. So, my lord, one thing is, there would be no question of, my lord, ultimately the delay to say that final notification.
He has lapsed on contention authority. Why are you arguing that they have not taken up that contingency?
All I am saying is if that ultimately. they are
Once
going
you
to say-
argue, we have to take up that.
Now, your lordships would say, if your lordships had to say that now because there is a delay in issuing the final notification, my lord, that would result, my lord, saying that we have not done anything with their particular land.
No.
Ultimately, my lord, they, on some ground, relief has to be given to them, my lord. Either saying because you have not done it within time, it has lapsed, or my lord, otherwise, my lord, on what ground, my lord, would they get a relief because of delay? Because we have subsequently passed an award, and if it is held that there is no time limit fixed for, my lord, passing the final notification, and if, my lord, we have issued and we have gone further by passing an award, and if that has taken place now, and that too out of the entire extent of land, more than 80% of the thing which we have already, my lord, we have got. Then to this small extent of land, can, my lord, that delay of issuing a final notification, insofar as this particular land is considered, can it be said that that Buddha is can't take this land? Because under something they'll have to, my lord, show that on what ground, my lord, because the delay would only result in these things only, my lord. Delay, yeah, all this section 11A and, of the Land Acquisition Act, all that came into picture only for the purpose of lapsing, and which, my lord, in Bondu Ramaswamy it was said, it is not, it's a self-contained code, and it can, so that is my submission with regard to that.
My lord, the
ಮುಗಿಲಿ ಅವರು ಯಾಕೆ ರೆಸ್ಪಾನ್ಸ್
ಅಲ್ಲ,
ಅವ್ರು ಮುಗಿಲಿ
ನಾ ಮುಗಿತು
ಕೊಡಿ
ಅಂತ ಕೊಟ್ಟೆ, ನಾ ಮುಗಿತು.
unless you want to dilute court's opinion.
Then, my lord, the judgment we have actually given that copy.
Saying,
my lord, that delay, my lord, cannot be there, and we have to proceed with the thing. And there, Shivana's judgment has been considered. Shivana's judgment has been considered, and some observations have been made whether it was called for or uncalled for.
ಕೊಡಿ. Compensation ಆಗೋದಿಲ್ಲ ಅದು. He came in the way. We wanted to say something which is not spoken of by any judgment. After Keswananda, compensation, the amount, word amount was used, 31C. Apex Court said, Apex Court in 3 judgments equated the word amount to compensation. All right. Please listen. We request you to be attentive to our submission. 300 capital A guarantees, it's a constitutional guarantee to right to property.
No more a fundamental right, but constitutional right.
Constitutional right. To acquire private property, 2 things are there. One, it should be in public interest. Number 2, it should be in accordance with law. 300 does not say pay compensation, etc. Word compensation is absent in that. In accordance with law is equated by the Apex Court to payment of compensation. All right. Now concept is clear. How this compensation is you are working out? On the basis of market value. All right. So the idea of the parliament is one who loses the property should get a recompensation. We agree with this? Recompensation will be on the basis of market value of the property. And market value of the property is certainly not on 1526 when Babur came to India. It has to be on a particular date. Apex Court in series of Aflatun, etc. said it should be asked on the date of preliminary notification. Court will take cognizance of the fluctuation in the market, real estate market. The prices of realty are going sky high. That's how capitalization method, this, that, all other method, 2017, etc. has come. Suppose if we permit you to brook delay with your explanation, we'll assume now that wonderful explanation you has given now. He will not get property rate which he would have got had you accomplished the process within reasonable time. This aspect is not to my limited exposure to law of land acquisition.
For that, the Honorable Supreme Court has held, then you would be entitled for interest.
That makes no sense. Interest does not is not compensation at all. Supreme Court said interest component we do not treat it as pure and simple component of compensation. It is statutory accrual.
But the Honorable Supreme Court has held that if there is a delay, because what happens is this: these are, my lord, the statutory authorities, my lord, these are not development by some private party or even AAV acquisition for a company. This is, my lord, for formation of site for economically poor people.
If that were to be, no, one second.
Authority does not act.
One second. If your logic is accepted, delay should not figure at all. Yes, you will get the interest.
Here also, my lord, delay, though, my lord, it is, my lord, now such a principle of law that though if the statute does not prescribe delay, my lord, reasonably it has to be seen and the court will look into that and say, see, the statute does not prescribe delay, doesn't mean that we can take 10 years, 20 years or 30 years.
No, your answer, that delay will be looked after by interest component. Then where the delay will be? There should not be delay at all. Should not be idea of delay at all. Even if it is 25 years, you will get interest for 25 years.
Then the question of all those lapsing and other things would come. Then all those aspects would come.
Lapsing is another concept. Lapsing is not enacted in this case. Lapsing of acquisition proceeding is not enacted in this, unlike 11A of 1894 Act. Lapsing of scheme.
Yes.
You are contradicting your argument. You argued just 5-10 minutes ago that even when scheme lapses,
acquisition will not lapse.
Therefore, it will be illogical. Overturning of the logic.
The thing why I made that submission that even if the scheme lapses, that acquisition will not lapse.
That is not their
that land will not go back to them.
Where have they taken up that ground? You want to add one more ground to their case?
No, that is.
They have not pleaded that at all. Para 16 of their petition is in a different context. Unless you want to add one more ground in their favor.
My only contention is ultimately, my lord, if a delay has taken place, now whether the acquisition can be set aside on the ground of delay only in passing the final note.
Set aside ಮಾಡಿದಾರೆ.
Beg your pardon?
Set aside ಮಾಡಿದಾರಲ್ಲ, 3 ಜಡ್ಜ್ಮೆಂಟ್ ಇದಾವಲ್ಲ.
Lord, I'll distinguish that and then I'll give the argument also. Right.
No, but time ಕೊಡಲ್ಲ. ಮುಗಿತು, ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಮುಗಿಸ್ಬೇಕು. ನೋ ಟೈಮ್. ನಮ್ಮ ಕೋರ್ಟ್ನಲ್ಲಿ ನಾವು ಕೊಡೋದು ಯಾರನ್ನೂ ಪ್ಲೀಸ್ ಮಾಡೋದೇ ಇಲ್ಲ ನಾವು. ಬಿಟ್ ಕರ್ಟ್ ಇನ್ ದಟ್. ನೀವು ಹೇಳಿ ನಾವು ಟ್ರೀಟ್ ಮಾಡ್ತೀವಿ. ಟೈಮ್ ಕೊಡಲ್ಲ ಆ ರೀತಿ. ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಮೇಲೆ ನೆವರ್ ವಿ ಹಿಯರ್ ದ ಮ್ಯಾಟರ್ಸ್. We are unpopular judges, but we want to be unpopular. We have taken oath to uphold the law. That's all, and justice, nothing beyond that.
But then my contention may be, my lord.
Noted, and this.
My lord, one more judgment I want to cite. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇದೆ ನೋಡಿ, ಈ ಸೈಟೇಷನ್ಸ್ ಇದೆಯಾ ನೀವು ಫೈಲಲ್ಲಿ?
Come to para 16 of Shivram Karnataka. You read para 16. You have to answer. Kodi, avರಿಗೆ judgment kodi, para 16. Shivanna, which you heavily pressed into, they say it is not good law. That was in the context of BD Act, but provisions are almost similar.
Same provisions are there in this.
Mr. Kulkarni,
My lord.
You have to answer that.
Yeah, that's I'm
Read that
reading.
paragraph.
I'm reading it, my lord.
Yes. On ಎರಡು judgments, they run counter to, they are nothing but Shivana. Those two, Amir Khan and they are nothing but Shivana in the duplication. If Shivana's ratio is doubted by this court, then their presidential value also will go. That having been
Same view with Mrs. Nagaratna is also taken by some.
correct. Yes, we shall see.
Shine monument.
Delay and latches. Any limitation, but it does not mean you can do it for one section. There has to be some sort of reason.
My lord, it is on principle of the lapse. I will read it, my lord, my understanding of this one.
Sure.
It does not delay with the delay. My lord, I will read it, para 16. Shivan, my lord, the court has emphasized the primary objection of the BDA Act is to carry out the planned development. The state has provided its own scheme. Time constraint of the land acquisition are not applicable to the BDA Act, making the applicable to frame of section 11A of the would debilitize the very object of BDA Act. It apparent that decision of the single judge or division bench would directly spoke the decision of the 5-judge bench of the offshore holdings, in which the precisely question involved in instant case are dealt with. By indirect method, making applicable to time period of 2 years, section 11A mandates that it has been violated. However, it is shocking that the various decisions that have been taken into consideration, particularly by single judge. However, where a decision that has not been controversy in the rest has not been noticed by the single judge by the or by the, if it is the case of the fact land laid on by the court that to a decision of a constitution bench, so much to say the exercise restraint in the use of power least better the way in which justice has to be done with the planned development of Bangalore Harbour left and merely unscrupulous. It is apparent of the fact the single judge has relied upon the decision of Shivarna, in which case of the judgment that the scheme would be completed within the period so it would lapse. My lord, we are not on the question of the lapsing of the scheme. We are considering with the delay. It was precisely the question time period which dwelt with upon the offshore holding case had violated single judge that to infringe violations of this. This is around the regarding of the lapsing of the scheme. We are not concerned with the lapsing of the scheme. We are concerned with the, my lord, the delay. Here in the Shoram case also, my lord, question was the lapsing of the scheme. And offshore.
BDA Act. Shivana was BDA Act. KIDP Act.
My lord, the Shivanna is, my lord, the
KIDP Act.
KIDP Act.
The other two are BDA Act.
Yes, my lord, the beard. And my lord, the
ಇದು Kuda.
Buddha.
Kuda.
Buddha.
Amir Khan is Kuda.
Amir Khan is, my lord, and the Buddha. That is for the authority anta. The constitutional authority anta. My lord, the yes, my lord, so I am not concerned with lapsing of the scheme. And my lord, this honorable court in a division bench.
Even Pradhanam, latest judgment, even when 11A is not applicable, proceedings have to be accomplished within reasonable period. Latest judgment.
My lord, I produced the unreported judgment of the, my lord, the passed by the division bench.
2019, 24 ಅನ್ನ ಡಿಸೈಡ್ ಮಾಡ್ತಲ್ಲ ಸೆಕ್ಷನ್ 24 ಡಿಸೈಡ್ ಮಾಡುವಾಗ ಇವುಗಳನ್ನೆಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರು ಅದರಲ್ಲಿ ಇಂದೋರ್ 2019 ಸುಪ್ರೀಂ ಕೋರ್ಟ್
And in the meanwhile, my lord, in respect of the Anugol scheme, same contention was taken and the final notification were quashed and it has become a final and writ appeal have produced it. This is in respect of a Kanabargi scheme. In fact, my lord, in respect of the my lord, lands were acquired under the Anugol scheme by the Belgaum Development Authority. I mean, this honorable court has held, since you are not my lord, the completed final notification within the reasonable period of time, on that ground, the writ petition was allowed and the writ appeal, they filed writ appeal, that appeal has become final. And I have produced along with my lord, the citations.
Their final notification was not issued at all.
In that, no final notification at all.
Here, and may I also request your lordship to turn to section 27 of the Urban Development Authorities Act, my lord. At the cost of repetition, my submission, my lord, your lordship will kindly pardon me for that. Section 27, similar provision of the BDA.
Lapsing of scheme.
No, but authority to execute the scheme within 5 years. Now, the scheme, execution of the scheme, my lord, it starts with the preliminary notification, my lord, approval of the government under 18, final notification under 19.
5 years.
So, my lord,
5 years from which date? Final notification, Alva. Final notification. Why are you saying preliminary notification?
No, I'm saying that execute the scheme and the scheme includes everything. So the delay now, final notification has been issued, award has been passed in this case. So, my lord, now if the award has been passed, final notification has been issued, then, my lord, the question would be whether, my lord, the delay.
Confusion.
That's what, my lord, the Honorable Supreme Court in this Shriram Karan, my lord, is not held that it is only under 142, my lord, because they still come to this.
Come to 27.
Yes.
Read 27.
Authority to execute the scheme within 5 years.
5 years from which date?
My lord, from section 19.
19.1.
Yes.
And that is final notification.
Yes. 19.1 is final notification.
Final notification. From that date, 5 years.
Yes.
But if you are issuing the final notification belatedly, that is his case.
But now, there is no provision which say.
You have said that no. With no
then
period.
Here also, even though, my lord, I said the authority fails to execute the scheme substantially.
He is not on that date.
But only for the delay in issuing the final notification when ultimately we have, my lord, issued and we have passed an award and we have taken all further steps. Why I am saying is to execute the scheme involves all these steps. That is my contention. So it cannot be, my lord, say that preliminary notification is issued. But there is no.
Why are you going to 20? He is not invoking it at all.
But then under what provision, my lord, then can it be set aside that because
On two grounds he is saying. He is not pressing 27. Hogo prashne illa avrdo.
But there has to be some provision under which, my lord, the acquisition can be set aside. If I can understand if final notification has not been issued, it can be set aside. But if final notification has been issued, award has been passed, we have proceeded further, then under what provision, under what thing it can be said that only because there is a delay, we set aside the acquisition. No, that cannot be done is in my humble, because there is no provision either under the Urban Development Act or the thing that if there is a delay in issuing the final notification, that it can be, my lord, the acquisition can be set aside. My lord, because it covers the entire scheme.
Yes.
My lord, in a writ appeal, my lord, I produced, my lord, along with the citation, writ appeal number 3044 of 2013. Cited unreported
The Supreme Court in Shriram Karan also say, if you leave it in the unscrupulous hands of either the authorities, though I am appearing for the authority, my lord, but your lordships are aware. So, my lord, if suppose some delays, your lordship will consider this. Now, for whatever reason, the lord, political interference, the division bench said that some lands have been denotified, that itself, the lord, will not give a right for others to seek for denotification. Negative equality, the lord, cannot be looked into. So, my lord, if there is some unscrupulous element, for whatever reason there is a delay, can the public interest be, my lord, ultimately, my lord, which will weigh in before this honorable court, the public interest or the private interest? Now, if the authority, my lord, for some reason, if the authority does not do it, like that's what the Honorable Supreme Court said, that you have not done it, we are directing you to do it. In fact, even in peripheral ring road, my lord, the Supreme Court said that you better implement it, though PD had given it up. So, my lord, this
judgment. ಅದಿದ್ರ ಜಜ್ಮೆಂಟ್ ಕೊಡಿ ಬುಡದ್ದು.
My lord, ಇದು ನೋಡಿ filed on 8/4/2014. Filed on 8/4/2014.
May I just request your lordship to read para 20 and 21 of the Shriram Samhita.
20 and 21.
Yes.
The judgment.
That is page 134.
ಇಲ್ವಾ?
Para 21. The scheme which was framed for so much benevolence means that 40% of the 55% of the land reserved for the residential purpose was given to the landowner at their choice, and they were also given the choice to obtain the compensation if they so desired under the provisions of the LA. Thus, it was such a scheme that there was no scope for any exclusion of the land in the ultimate final notification. It is apparent from the circumstances that the matter cannot be left at the mercy of unscrupulous authority of the DDA, the state government, or in the political hands. Considering the proper development and planned development of Bangalore, let the government issue a final notification with respect to the land which has been notified in the initial notification. And there is no question of leaving out the land in the instance as the option has been given to the landowner. Paragraph. It was written on behalf of the landowner that certain developments have taken place after the orders were passed regarding the exclusion of land and when section 21 provides.
ಅಲ್ಲೇ paragraphs 16, 20, 21, 22, 23. 16 ಇಂದ 24 ವರೆಗೆ.
Para 24 and 25. Para 24 and 25 of the said judgment.
Yeah. To be discussed.
We have no hesitation in condoning the delay.
Yes.
Though it's apparent that the authorities have come up with certain delay in certain matters of so and so, related to the delay of High Court. However, considering the provisions of the scheme and the method and the manner, wrong has been committed. It is compelled us not only to condone the delay but also act in the matter so as to preserve the sanctity of the legal process. We therefore direct the state government as well as the DDA to proceed further to issue final notification without any further delay in the light of the observations made in the order. The impugned order passed by a single judge so and so. So, my lord, here final notification was not passed. The Supreme Court said, please pass the final notification. Now, my lord, we are in a case where final notification has been passed, the final notification has been issued. So, we are better off than even in this case, my lord, where they say the unscrupulous, your lordship may kindly see, for whatever reason, my lord, this, if you are acquiring, if it's for public interest, my lord, now the authority delays for whatever reason. And my lord, the public interest demands that it should be, if your lordship says that the scheme itself is not warranted, it could not have been taken up, then I can understand. Power of eminent dominant lord, your lordships, I don't, all these things I don't have to tell my lord, your lordship, the way, my lord, I don't have to say those things and argue on those aspects of the matter at all. So my lord, when here in the Supreme Court said, please issue a final notification now.
It's a apex court in any constitutional setup. Highest court of the land will have special powers.
No, this is not under
which we cannot have. They have said this is done under 142 in another judgment. ಇದರಲ್ಲಿ ಹೇಳಿಲ್ಲ ಇದನ್ನೇ ಇನ್ನೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಮೆನ್ಷನ್.
Your lordship, my lord, initially I didn't say, my lord, because your lordship said, so I thought I have not seen that. Even now, my lord, subject to correction. In this, my lord, it is not 142.
Yeah, not.
It is not 142.
It is said to be 142 in another matter. ಇದನ್ನೇ ಇದರಲ್ಲಿ 9 ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಬಂತು ಒಟ್ಟು. ಇದಾದ್ಮೇಲೆ 9 ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಬಂತು. ಒನ್ ಆಫ್ ದ 9 ದಲ್ಲಿ ನಾವು ಇದನ್ನೆಲ್ಲ 142 ಕೆಳಗೆ ಮಾಡ್ತಾ ಇದ್ದೀವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅದಕ್ಕೆ ಇದರಲ್ಲಿ ಹೇಳಿಲ್ಲ.
But here, your lordships also, my lord, 142, your lordships are not exercising the power. Your lordships, my lord, are exercising the power under but here, if your lordship sees what is this for, my lord, for the development of what is the scheme meant for, my lord, if already 80% has already been substantially implemented. Now at this stage, it is not as though, my lord, we didn't issue a final notification. We have issued the final notification, though there is a delay. But the delay has been explained, but from preliminary to final notification, that particular, but there is no provision, my lord, which says that it has final notification has to be passed.
You have said it about half a dozen times now. there is no statutory limitation ಅಂತ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಅನ್ನು ಹೇಳ್ಬೋದು. ಅದನ್ನ ಒಂದು 2 ಸರಿ ಹೇಳಾಗಿದೆ ನಿಮಗೆ. ಹೊಸದೇ. New things, ರಿಪೀಟ್ ಮಾಡಬೇಡಿ. ನಾವು ಅಫೆಂಡ್ ಆಗ್ತೀವಿ. ನಮ್ಗೆ ಏನಿಸ್ತು ರಿಪೀಟ್ ಮಾಡ್ದಾಗ ಹಂಗಾರೆ ಅಷ್ಟೊಂದು ದಡ್ರಿದ್ದೇವ ನಾವು ಇಷ್ಟು ಸಾರಿ ಹೇಳಿಸೋಳು ಅಷ್ಟು ಅಂತ ಅನಿಸ್ತದೆ ನಮ್ಗೆ. ಹಂಗ್ ಮಾಡಬೇಡಿ. You have said that. Go to new point. Any new point, any virgin point, you can urge.
ಅದು ನಿಮ್ಗೆ ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ ಅಂತಲ್ಲ, ಅದು ನಮ್ಮ ಆಂಗ್ಸೈಟಿ ಅಷ್ಟೇ.
ನಿಮ್ಮ anxiety
Many a times, my lord, when we submit, it is not as though your lordships are not understood, but we, my lord, for our satisfaction.
ಅಲ್ಲಿ ಬೇರೆಯವ್ರು ಕಾಯ್ತಿರ್ತಾರೆ ಅಂತ. ಬೇರೆಯವರು ಏನ್ ದಡ್ಡ ಜಡ್ಜ್ಗಳಪ್ಪ ಎಷ್ಟು ಸರಿ ಹೇಳೋದು ಇವ್ರಿಗೆ ತಿಳ್ಕೊಳ್ಳಿಕ್ಕೆ ಅಂತ ಅನ್ಕೊಂಡು ನಿಮ್ಮನ್ನ ನೋಡಗಲ್ಲ ಅವರು ನಮ್ಮನ್ನ ನೋಡಕ್ಕಾಗ ಅದು ಭಯ ಇದೆ ನಮ್ಗೆ. ನೀವು 3 ಪಾಯಿಂಟ್ಸ್ ಅಲ್ಲ
I will be satisfied that I have made all my submissions.
That's right. No, suppose if you are not satisfied ad nauseam, can we go on hearing it for it? Therefore, there has to be, we have said now, the first one is authority has considered the objections. So 2 persons are high functionaries and all were present. They have marked the attendance register. That amounts to marking the resolution itself, because section does not say everybody should sign. This is one thing. Number 2, you say there is no statutory limitation unlike under 1894 Act. Therefore, you cannot read the limitation of one act in another act. Number 2 is over. Number 3, assuming that there is delay, we have explained it in para 4 of your second additional statement of objection filed on 12/12/2022.
Part of the writ petition itself, not an afterthought.
2016 first objection statement, it was filed in November.
In general, yes.
Then the second statement of objections was filed in 2021. The third statement of objections has been filed on 12/12/2022.
Objections with documents. It's not an afterthought. I've just said something to justify. It is with documents that you have to consider that.
Correct.
So that it is not simply an afterthought. We try to explain as to why.
Fourth point is that the scheme will not lapse. Assuming that scheme has lapsed, the vesting of land will not be affected, that you will continue to be owner of the land. Then the last one is Shivanna's ratio is doubted by the apex court, which we pointed out to you. And therefore,
I wanted to, but I said at the outset,
anyway,
Shivanna's has been referred. They made certain comments also. I said that your lordship will not stop me by saying 142, so my lord, I kept it. I made that sufficient. Shivanna's, my lord, I marked it here, my lord.
Is doubted. Shivanna's ratio is doubted. Shivanna's version in Amir Khan is nothing but Shivanna only. Therefore, once Shivanna is doubted, Amir Khan is also doubted.
Yes.
These were submissions.
And one last, with regard to signing, present and voting, this cannot be equated with regard to the voting where there is either disqualification proceedings or where somebody has to be removed, where it prescribes. So this cannot be equated at that level to say that all of them have to.
Anything more?
There are 3 unreported judgments. I filed it. My lord, there were
These
2.
are all unanimous that taking the authority to acquire them. So this should not be equated to that. That's at a higher pedestal, not where they all have to be present because somebody's thing about his continuation in office is being taken. This cannot be equated.
What are the 3 unreported judgments in respect of a lands which has been acquired by the same authority? My lord, na ಕೊಡ್ತೇನೆ ಅದು ಇಲ್ಲ ಅಂದ್ರೆ na ಕೊಡ್ತೇನೆ. My lord, the lands which have been acquired in respect of a Angol village, for them, my lord, the same Belgaum Development Authority.
ಆ ಸ್ಕೀಮ್ ಅಲ್ಲಿ ಬೇರೆ ಸ್ಕೀಮ್
ಅಲ್ಲ, ಸ್ಕೀಮ್ ಒಂದು ಅಥಾರಿಟಿ ಸೇಮ್ ಲೀಗಲ್
ಸ್ಕೀಮ್.
My lord, this is for the Angol land. Now this is for a Karnataka land. This is a different scheme by the same authority. The court held, my lord, the acquisition beyond the period of 2 years, relying upon the Shivanna's case held, my lord, it is void and the final notification has been quashed. My lord, there are 2 unreported division bench and my lord, the single judge, my lord, the same single judge, my lord, who has passed this order. And the first judgment is the learned single judge, 2 judgments are division bench. And my lord, the same single judge relied upon the division bench judgment. In that case, my lord has quashed, but in this case, my lord, he has not quashed.
ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕು ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್. ಇಟ್ಸ್ ಎ ಪ್ರೊಸೀಜರ್.
I had submitted Final notification was not issued.
That case makes your case worse, sir.
No, if final notification is not issued, the Honorable Supreme Court will issue the final notification.
Adu-
I have issued a final notification. Their final notification itself is not issued.
Suppose you issue preliminary notification. For 15 years, he keep quiet. You mean to say that if that is quashed,
No, no. Final
And-
notification, if final notification has not been
issued,
then it can be quashed, because final notification has not been issued. Then it can be quashed.
Huh.
Here, in this case, in our case, in the instant case, final notification has been issued.
how it makes difference at that?
No, there are two things. When a person
With
comes to the court challenging,
Oh.
look,
Final notification you have not issued, but preliminary notification was issued, and the authority slept over the matter for years. That has been set aside by the court.
because no final notification. Yes.
Final notification is issued after years after the preliminary notification.
Here, but
How ratio will change, quality of the ratio.
And you know this Srikanth judgment shows that here we have issued the final notification, we have proceeded further. It is not as though we have not proceeded further. And from 2010 onwards, from that day, we have explained the entire thing by producing all the documents. Your lordships have said around that 3 objections. I can understand if I had just made some oral submission, this took time, that took time. No, my lord, it is the reason why I was trying to point out that 40 and 60 scheme, 50 and 50 scheme which we are giving. So this was for the benefit. So at once, my lord, we have the power of eminent domain. My lord, then these things cannot. In fact, my lord, the Honorable Supreme Court has gone to the extent of saying, my lord, once I have acquired the land for a particular purpose, if I don't utilize it for that purpose, my lord, they can't challenge it, my lord, because that is in Galande's case. Sumitra Galande case, they have said that they can't challenge that. I can use it, and in fact, now the latest given by Justice Abhay Srinivas Hope, but they have said that that particular land, I can keep it and utilize it later because I can keep it as a land bank. Because we may need it even further after 20 years or 30 years. So once it vests, it's no question of divesting. Ultimately, my lord, it's at that stage. So I have issued the final notification. I have explained that delay. Yes, from the preliminary notification till the final notification. No, that is not a delay on which, my lord, this honorable court should set aside the. Lord, ultimately, again, the acquisition itself, your lordship will have to set aside. Acquisition will be set aside on a particular ground only, my lord. Then that ground,
Yes. Third result.
Connected matter I am appearing for respond 417. This is kindly see.
Anything new to be stated?
Same, only I am bringing some special facts in this case. In this case, preliminary notification was not at all issued.
Not at all issued.
Not at all issued. And abruptly they.
All. Other preliminary notification is here?
Yes, mistake in survey number.
Allah.
There was mistake in survey number. We are
That's
sure
the
origin subsequently.
Origin.
And it is not the case that they have got another land apart from this land. It's only one land. I have put the objections also.
So this is first point that it was not.
On that
Counsel for the
100,417.
appellant in a writ appeal number?
Writ appeal number 100,417 of 2023.
Submits that. In this case, there was no preliminary notification at all. How learned single judge treated it?
He is in the light of the decision.
The corrigendum is treated as preliminary.
In the light of the decision passed in this companion matter, all the matters are remitted back. So no further any reasoning is given.
The panel counsel submits that corrigendum has been issued by rectifying the survey number and that the landowner has no other land than the one comprised in the corrigendum.
For that, my submission is that
Number one.
this
Next.
corrigendum cannot take place, or it cannot be substituted for the procedure enjoined under 17(1) and 18(1). Therefore, corrigendum.
Which other land do you have?
I do not have any land. It is
this land
in the corner land only. But my submission is that since I have not heard it all, my objections are not considered.
Did you file the objections?
No notice is issued to me.
No, we are asking you.
No, I did not.
Answer the point directly.
I did not.
Since the land was not notified in the preliminary notification, the question of filing objections would not arise. Question
Then-
of, since the land is not comprised in the preliminary notification, comma, the counsel for the landowner submits, comma, the question of filing objections would
No
not
notice.
arise.
No notice. Then annexure D, they have given NOC to me on 2/2/2013.
The Buda has issued no objection certificate
Please.
dated
2nd February 2013. That is after lapse of 6 years.
2013, comma, the preliminary notification being of the year 2007. 2007 ತಾನೇ ಅದು?
ಹೌದು.
2007. And that also supports the case of the appellant that
Then
the
next
land
my
was
submission is
notified
that
for acquisition.
I press into service the decision rendered in writ appeal, which is annexure A, wherein I will read what your lordship your point time and again, you're asking the same question is dealt with here and answered. May I read only short para?
ಏನ್ ಪಾಯಿಂಟ್
ಅದೇ
ಪ್ರಪೋಸಿಷನ್
ಪಾಯಿಂಟ್ ಇರೋದು ಇಷ್ಟೇ that it is pegged down to the market value your lordship were expressing same only 4 lines.
ಗೊತ್ತಾಗಿದೆ, we have said that.
So that decision I have placed into service saying that beyond 2 years they cannot issue the final notification. In this case what they have after lapse of 7 years they have passed
They have case.
this is annexure E I have produced ink page 60 in this for
Case ಹೆಸರು
case writ appeal number 30936 of 2012.
ಕೇಸ್ ನಂಬರ್ ನೀವು ಬ್ಯಾಂಕ್ ಮಾಡಿ
Unreported document are given.
ಹಾಕಿದ
Unreported, but I have produced, it is part of this proceeding only, and it is accepted. So my submission is that in the light of this issue, wherein it is considered that since they cannot be indolent and they cannot sleep over for more than 2 years after issuance of 17(1), and whatever delay explained, as your lordship has pointed in the companion matter, when I argued the matter, when I brought all these facts to the notice of the court, then court asked an explanation, whereupon they filed one affidavit. But in that affidavit, it was conspicuously missing as to the delay aspect. Therefore, again they sought time and filed thereafter the delay application. Therefore, delay is the ground on which next point is this one. Now, so far as this appeal 417 is concerned, my submission is that there is no procedure as enjoined under the act is complied with. And since we are not challenging the order under appeal, we want to go back and establish that this land is not at all required. And one more submission, in all, there are 160 acres of land is sought to be acquired. In that, in the companion matter, 22 acres, in this matter, 1 acre. Apart from that, there is a private layout of 15 acres, wherein the private houses have already come. They also issued demolition notices against which the petitioners came. They have filed writ petitions and stay is granted. Therefore, all that land which they are showing is available is not at all available as on date, because during the period of 7 years, more than 50 sale deeds have taken place. They have given this conversion orders, land use and all that. They have issued the NOC as which I pointed out. So all these things make it clear that they have by their conduct abandoned the scheme. In fact, in companion matter, I use the word lapse, that is wrong. I understand, but the conduct shows that they have abandoned the scheme, Therefore, so far as this appeal is concerned, my submission is that the impugned order which is remitting back them needs to be confirmed. This is one. Then in second companion appeal,
remitting order,
in fact, remitting order, I should have preferred appeal here
you have not
because
preferred appeal.
I have not preferred appeal. So I am ready to go, but for that they have to again issue 17(1) for that, because they cannot initiate the proceeding without 17(1) against me. Then in the companion matter,
ಕುಲಕರ್ಣಿ ಅವ್ರದ್ದು ಒಂದು ಅದರಲ್ಲಿ ಅವ್ರ ಅಪೀಲು ಪ್ಲಸ್ ನಿಮ್ದು ಅಪೀಲು ಎರಡೇ ಅಂತ ರೆಮಿಟನ್ಸ್ ಈಸ್ ಬ್ಯಾಡ್ ಅಂತ ಅವ್ರದ್ದು ರೆಮಿಟ್ ಮಾಡಬಾರ್ದು, ರಿಮೈಂಡ್ ಮಾಡ್ದಂಗೆ ಮಾಡಬಾರ್ದಿತ್ತು ಅಂತ ನಿಮ್ದು ರಿಮೈಂಡು ಮಾಡಬಾರ್ದು, ನಿಮ್ದು ರಿಮೈಂಡ್ ಅಪ್ಲಿಕೇಶನ್ ರೈಸ್ ಆಗಲ್ಲ, proceeding should be allowed to continue ಅನ್ನೋದು ನಿಮ್ದು.
then in 418 another appeal. This is a batch of this is 22 acres of land. In this, all these farmers
ಅಪೀಲ್ ಅದು
ಅಲ್ಲ, ಅವರು ಅಪೀಲ್ ಹಾಕಿದ್ರೆ ನಾನೇ ರೆಸ್ಪಾಂಡೆಂಟ್.
ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್,
ಹೌದು,
ಲ್ಯಾಂಡ್ ಓನರ್ಸ್.
In this, what has happened that we filed writ petition in the year 2013, because after issuance of 17-1, they did not issue final notification. Therefore, we approved because they were not allowing to develop our property and or issuing any or cooperating. Therefore, we filed application seeking declaration that the scheme is lapsed. Of course, this framing is wrong. I concede. Now, when we filed this writ petition, by then, final notification was not issued by them. 19-1 was not issued. When I filed this writ petition in question, thereafter, during pendency, they were provoked to by the persons who are having vested interest. They were provoked, and thereafter they passed the 19-1. They have not issued notice to us. This is one. Thereafter, they have also passed award also. All these things have done in the year 2013 and 14, of which we are not at all aware of. This is one thing. Second is that we brought to the notice that we are not heard in the matter properly, because we wanted to bring all these facts to the notice of the authority. But authority cryptically passed the order. Therefore, it is not proper on the part of the authority in not giving a proper hearing to these petitioners. And besides, we were again, the same contention was raised that delay is the a main trump card. So from 7 to 13,
You have said that.
are the same ground is taken. Therefore, here also the matter is remitted at the stage of 17-1. So far as this branch is concerned, 17 holds good. But in that case, 17-1 is also not issued. Therefore, I leave it to your lordship. So my submission is that whatever order is passed by the learned single judge, that is correct.
One fact I will.
I've not seen my mistake that in the first objection itself, we have given the details as to why there was a delay. There was a lot that there was an amendment to the rules instead of 46 days, 50. All these things have been explained in the first objection itself. However, we have given much more clarity to producing all the communications we had with the government subsequent, but in the original objection, all these things have been stated.
In the, Mr. Kannur submits that in the original statement of objections, delay in issuing the final notification has been meticulously explained. What have you said about 3 years delay from 2007 to?
Very the subsequent also, you also pointed out that.
No, we are asking you.
Yeah, we are not saying.
However, in all fairness, he concedes that nothing has been stated as to why 3 years lapsed during the period between issuance of the preliminary notification and submission of proposal to the government in September 2010 in relation for changing the user of the land for residential purpose.
My lord.
And not one more thing we have also out of 156 acres, ultimately not the litigation is only in respect of about 18 or 20 acres.
No. This is incorrect.
Incorrect.
More than, like I just said,
Yes,
under the
215 acre layout there is number 22 plus 15.
37.
106 acres, 23 kundas may not by consent, may not they given the land. But then general award has been passed in respect of another 29 acres. So now only about 20 or 25 acres of land are in this which are before your objection. And the other thing is what we have, so that map, what we have produced is how we are developing it. Why I am saying that it's not we can also see like how it is being developed. And since all of them have come along, so these points also your lordship can consider that. But what may happen is this, because if an island is formed in a place I can understand.
Now, here a question.
Whether the possession of the land is taken.
Possession tondira?
Illa.
Whether award is passed. In their case.
Yes.
But possession is not taken.
Award is approved by the government?
Yes.
Approved by the government. When it was approved? Approval, government the order kodi approval of the award madiddu?
But no possession is taken.
And the possession of subject lands has not been taken, is conceded before the court on being specifically questioned. Award was approved by the government when?
After passing the award, they have to.
Which, who should approve the award under the act?
Government circle is.
We do not. Whether the power to approve can be delegated? Which section? Approval of the government. Mr. Kannur, yavudu?
Governed by land acquisition. Not this.
12, right?
It is governed by land acquisition. Hindi ಬರಲ್ಲ ಅದು.
This act is
It is
incorporated.
Okay.
And the award proceedings are incorporated. Award proceedings of
1894 is incorporated. 12, approval of the award under section 12. Power to approve ಯಾವುದು? ಯಾವ ಸೆಕ್ಷನ್ ಕೆಳಗಡೆ ಅಪ್ರೂವಲ್ 12 ಸೆಕ್ಷನ್ 12 ಆಫ್ 1894 ಆಕ್ಟ್ ಕೊಡಿ 1894
Land Acquisition Act.
Section 36 land acquisition.
ಅಪ್ರೋಪ್ರಿಯೇಟ್ ಗವರ್ಮೆಂಟ್ ಅನ್ನೋ ವರ್ಡ್ ಇದೆ. ಸೊ ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ಟು ಅಪ್ರೂವ್ ಇಟ್. 11 proviso. Provided that the award shall be made by the deputy commissioner.
Land acquisition act.
Yeah, ಸರಿ ಇಲ್ಲ. Provided that the award shall not be made by the ಆಗ್ಬೇಕಾಗಿತ್ತು. Original act ಕೊಡಿ 1894 act.
The award shall be made by the deputy commissioner without the presence of the state government. Joined in this behalf, who in the case of.
Without the, ಅದಕ್ಕೆ section ಏನೋ ಮಿಸ್ಟೇಕ್.
Inquiry.
Provided that
Amendment by
the award shall be made.
1961.
No award shall be made.
1961.
Under this without
The delegation.
No award shall be made.
But specify ಮಾಡಬೇಕು ಅಷ್ಟೇ ಅದು.
Section ಎಷ್ಟು?
Section 11. ಹೆಚ್ಚಾತ್ ಅರ್ಬನ್ ಇದು ಲ್ಯಾಂಡ್ ಎಕ್ವಿಸಿಷನ್.
ಅದಕ್ಕೆ ಅನ್ನಿಸ್ತಂಗೆ ಇಲ್ಲ ರಾಂಗ್ ಪ್ರಿಂಟ್ಸ್ ಎಲ್ಲ. Go to the original act. No award shall be made without the approval of the government. Cannot be like that. ನೋಡಿ ನಮ್ಮ ARG ಫೋನ್ ಮಾಡಿ ಅವ್ರಿಗೆ ಹೇಳಿ send a letter to Puliani saying that you have wrongly printed the section ಅಂತ ಹೇಳಬೇಕು. ಅಲ್ಲ ಯಾವಾಗಾಯ್ತು ಅಪ್ರೂವಲ್? Who is the government? Appropriate government. Where is the power to delegate? Or such officer.
And one other aspect of the review of what they have to use that land, because to show like how we are developing the land, because the entire area, as I said, 80% of they already considered, so now we are developing. Now this 1 acre 38 we cannot leave it out. Because if we leave that out, then all the other roads that we have explained about and given that along. If this becomes an island, even
Mr. Kannur submits that land comprised in Mr. Kulkarni's appeal. The land comprised in the appeals cannot be left out in as much as they have contiguity with the land to be developed in terms of the map in question. And 80% of the landowners have already given consent for acquisition. And that the possession of that 80%.
I don't dispute all those things. It is not out,
our land.
no, out of the pleading, out of the evidence.
It is not done.
It should not be, his submission to that effect may not be taken into account. No, no, no. No, no, nothing has been pleaded. No pleading. No, I replied.
Contention.
Because what happened is, there was a thing to settle between the two of them.
ಅಲ್ಲ, ಈಗ ನೀವು ಆ ಲ್ಯಾಂಡ್ ಅನ್ನ ತಗೊಂಡಿದ್ದಾರೆ, ಅದು ಕನ್ಸೆಂಟ್ ಅವಾರ್ಡು ಅನ್ಕೊಂಡು ಎಲ್ಲರ ಒಂದ್ ಸ್ವಲ್ಪ ಪ್ಲೀ ಬೇಕಲ್ಲ. ನೀವು ಹಂಗೆ ಅಲ್ರಿ, ಅದೆಲ್ಲ ಆಗಿದ್ದನ್ ಕೋರ್ಟ್ ಮುಂದೆ ಏನಾದ್ರು ಹೇಳಿದ್ರ ಹೀಗೆ ಅಂತ, ಹಂಗೆ ಎಲ್ಲದನ್ನು ನೀವು ಹೇಳ್ಕೊತ ಹೋದ್ರೆ ಏನ್ ಕೇಳ್ಕೊತ, ಅದು ಕರೆಕ್ಟ್ ಇದೆ ಅವ್ರು ಹೇಳೋದು. ಅದನ್ನೆಲ್ಲ ನೀವು ಹಂಗೆ ನಿಮ್ಗೆ ಏನ್ ಬೇಕಾದ್ರೆ ಹೇಳಕ್ ಬರಲ್ಲ. ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಂದ್ರೆ ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ ಇರ್ಲಿ, ಅನರ್ ಅಡ್ವೊಕೇಟ್ ಇರ್ಲಿ, ನಿಮ್ದು ಇದ್ರಲ್ಲಿ ಪ್ಲೀ ಏನಿದೆ ಅದನ್ನ ಹೇಳಕ್ ಬರ್ತದೆ. ವೇರ್ ಹ್ಯಾವ್ ಯು ಟೇಕನ್ ಅಪ್ ದಟ್ ಕಂಟೆನ್ಷನ್ ಅಂತ ಅವ್ರು ಹೇಳೋದು.
One last submission. I filed an application for appointment of a commissioner to find out now the private owners have developed the land. 50% of the land has been developed now by the private owners. They have constructed building.
ನೀವೆಲ್ಲ ಆ ಕಂಟೆನ್ಷನ್ ತಗೊಂಡಿರಿ?
ಆ ಕಂಟೆನ್ಷನ್ ತಗೊಂಡಿಲ್ಲ, ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡಿದ್ದೆ. ಅಲ್ಲಲ್ಲ ಅದನ್ನ ಆ ಕಂಟೆನ್ಷನ್, ಅದಕ್ಕೆ ಒಂದು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಫ್ ಕಮಿಷನರ್ ಅಂತ ಹೇಳಿ ಹಾಕಿದ್ದೇನೆ ಅಪ್ಲಿಕೇಶನ್. ಅದು ತಾವು ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಂತ ಅಷ್ಟೇ ಹೇಳು. ಅಲ್ಲ ಸ್ವಲ್ಪ ಅಲ್ಲ, ನಾನು ಹೇಳುವಾಗ ಹೇಳ್ತೇನೆ. ಅದು ಆಮೇಲೆ ನೋ ದಟ್ ಇಸ್ ನಾಟ್ ಶುಡ್ ಬಿ.
ನೀವು ಅವರಿಗೆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ಲಿಕ್ಕೆ NOC ಕೊಟ್ಟಿದ್ ನಿಜಾನಾ?
ನನಗೆ ಕೊಟ್ಟಿಲ್ವಾ? ಅಲ್ಲ, that is given by them. That is not disputed. It is not disputed.
Some of them, because they thought it is abandoned, they have not that there is an act. After the preliminary notification,
ನಾವು ಕೇಳೋದನ್ನು ಉತ್ತರ ಕೊಡಿ. ಅವರು NOC ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರು. ತೆಗಿರಿ ನೀವು NOC.
Annexure D 417 ನಲ್ಲಿ 417 writ appeal, 100-417 Annexure D.
Others need not wait. Come after in the second session. This will take some time. ಎಲ್ಲಿ
ಇಲ್ಲಿ ಕೊಡಿ, ಒಂದೇ ನಿಮಿಷ ಕೊಡಿ. ಹೌದು, ಅಲ್ಲ ಡಿನೋಟಿಫೈ, NOC ಅಂತ ಕೊಟ್ಟಿದೆ, ಡಿನೋಟಿಫೈ.
Have you denied in your objection statement that ಇದಕ್ಕೆ ಸಿಗ್ನೇಚರ್ ಸೈನ್ಡ್ ಇದೆ?
It is issued by them only.
ಏನಂತ
ನೋಟಿಸ್ ಅಲ್ಲ.
ನಮ್ಮ ಪ್ರಶ್ನೆ ಏನು ಹೇಳಿ? Tell us what we have asked you. ಅಲ್ಲ, ನಮ್ಮ ಪ್ರಶ್ನೆ ಏನು ಅಂತ ಅರ್ಥ ಮಾಡಿಕೊಂಡ್ರೆ ನಮ್ಮ ಇಂಗ್ಲಿಷ್ ತಿಳಿತಾ ಏನು? Annexure D ಪೇಜ್ 58 ನಲ್ಲಿ ಅವ್ರಿಗೆ ಸರ್ಟಿಫಿಕೇಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. ಇದು ಸುಳ್ಳು ಸರ್ಟಿಫಿಕೇಟ್, ನಾವು ಇಶ್ಯೂ ಮಾಡಿಲ್ಲ ಅಥವಾ ಇಶ್ಯೂ ಮಾಡಿ ತಪ್ಪಾಗಿದೆ. ಏನ್ ಸ್ಟ್ಯಾಂಡ್ ಇದೆ? ಏನ್ ಮೊದ್ಲು ಇಂಗ್ಲಿಷ್ ಎಲ್ಲ ಕಲ್ಸಕ್ ಆಗಲ್ಲ, ಲಾ ಸ್ವಲ್ಪ ಹೇಳ್ಬೋದು ನಾವು. ನಮ್ಮ ಪ್ರಶ್ನೆ ಏನು? ಏನ್ ಪ್ರಶ್ನೆ ಹೇಳಿ?
University was given, there was some mistake, that's a proceeding was issued. I have put some proceeding also, and also issued the objection filed.
ನಾವು ಸಿಂಪಲ್ ಕೇಳ್ತಾ ಇದ್ದೀವಿ, ಕನ್ನಡದಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದೀವಿ. ನಿಮ್ಮ ಅಧಿಕಾರಿ ಇದನ್ನ ನೀವು ಮನೆ ಕಟ್ಟಿಕೊಳ್ಬಹುದು ಅನ್ಕೊಂಡು ತಮ್ಮ ನಿರಪೇಕ್ಷ ನಿರಾಪೇಕ್ಷಣ ಪತ್ರವನ್ನ ಕೊಟ್ಟಾರಪ್ಪ. ಇದು ನಿಜಾನ ಸುಳ್ಳು? ಇಶ್ಯೂಡ್ ಅದನ್ನ ಒಪ್ಕೋತೀನಿ, ಅದನ್ನೇ ಕೇಳಿದ್ವಿ ನಾವು. ಸುಮ್ಮನೆ ನೀವೇನಾದ್ರು ಒಂದು ಟೆಂಪ್ಟೇಷನ್ ಮೇಲೆ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾರೆ.
We have given objection and we are equal issue. And this will also see election.
ಅದು ಸ್ವಲ್ಪ ಅದನ್ನ ಓದಿ, ಇನ್ನು ಸ್ವಲ್ಪ ಓದಿಸೋಣ ನಿಮ್ಮ ಕೈಯಿಂದ. ಈಗ ಓದಿ. ನಿಮ್ಮ ಉದ್ದೇಶ ನಮಗೆ ಎನ್ಲೈಟನ್ಮೆಂಟ್ ಮಾಡಬೇಕು, ನಮ್ಮನ್ನು ದಣಿಸೋದಲ್ಲ. ಅವಾಗ ನಾವು ನಿಮ್ಮನ್ನು ದಣಿಸ್ಬೇಕಾಗ್ತದೆ. ಓದಿ ಅದನ್ನ, ಬನ್ನಿ. ಭೂಸ್ವಾಧೀನತೆಗೆ ಒಳಗೊಂಡಿರುವುದಿಲ್ಲ. ಭವಿಷ್ಯದಲ್ಲಿ ನಾವು ಮುಂದೆ ಅಕ್ವೈರ್ ಮಾಡಬಹುದು, ಹೌದಾ? ಹಂಗಾಗಿ ಅವ್ರ ಸ್ಟ್ಯಾಂಡ್ ಇದೆಯಲ್ಲ 4(1) ನಲ್ಲಿ ನಿಮ್ಮ ಪ್ರಿಲಿಮಿನರಿ ನೋಟಿಫಿಕೇಶನ್ 17 ಅದರಲ್ಲಿ ಇಲ್ಲ ಅನ್ನೋದು ಇದರಿಂದ ಸಾಬೀತಾಗಲ್ವಾ?
Mistake in 7 numbers. That's the point understood. And as I said earlier, it is not that they have another value apart from this. And they have my objection to their
ಕಾರಿಜೆಂಡಮ್ ಯಾವತ್ತು ಇಶ್ಯೂ ಮಾಡಿದ್ದು?
ಪೆಂಡೆನ್ಸಿನಲ್ಲಿ ಮಾಡಿದ್ರು, ಡ್ಯೂರಿಂಗ್ ಪೆಂಡೆನ್ಸಿ along with additional statement of issue. It is annexure ಅಲ್ಲ ನನ್ನ ಫೈಲ್ ಅಲ್ಲಿ
ಕಾರಿಜೆಂಡಮ್ ಕೊಟ್ಟಿದ್ದೇವಲ್ಲ, ಡೇಟ್ ಆಫ್ ಕಾರಿಜೆಂಡಮ್ ಹೇಳಿ.
ನಂದು ಫೈಲ್
ಇದು ಅಲ್ಲ, ಡೇಟ್ ಕಾರಿಜೆಂಡಮ್ ಎಲ್ಲಿದೆ? ಇತ್ತೊಳ್ಳಿ ಅವ್ರದ್ದೇ. ಕಾರಿಜೆಂಡಮ್ ಇಸ್ ಡೇಟೆಡ್.
It is Corrigendum
2013.
Huh?
Additional statement of additional objections, sir. Additional objection statement.
Corrigendum ink page 84 you.
Huh?
Ink page 84.
2000?
ಅಲ್ಲ ink page 84 Corrigendum produce ಮಾಡಿ. ಈ 417 ಅಲ್ಲಿ. It is dated 12/8/2013.
12/8/2023 ಇಶ್ಯೂ ಮಾಡಿದ ಮೇಲೆ ಈ ಕಾರಿಜೆಂಡಮ್ ಕೊಟ್ಟಿದ್ರಲ್ಲ, ನೋಡಪ್ಪ ಅದು ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ, ಕೊಟ್ಟಿತ್ತು, ಇದು ಮಾಡಿದೇವಿ, ಅದನ್ನ ವಾಪಸ್ ತಗೋತೀವಿ ಅಂತ ನೋಟಿಸ್ ಕೊಟ್ರ? ಬರ್ತದಿಲ್ಲ, ಯಾಕಂದ್ರೆ ಇದನ್ನ ಇಶ್ಯೂ ಮಾಡಿದ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡ 5 ಈಗ 12/8/2013 ಕಾರಿಜೆಂಡಮ್ ಇಶ್ಯೂ ಮಾಡಿದ ಮೇಲೆ did you issue personal notice to the litigant landowner? ನೋಡಪ್ಪ ನಿಮ್ದು ಹೆಸರು ಇದ್ರಾಗ ಇನ್ಕ್ಲೂಡ್ ಮಾಡಿದೇವಿ, ಇಂದ ಅಬ್ಜೆಕ್ಷನ್ ಇದ್ರ ಹಾಕಿ ಮಾಡಿಲ್ಲ. Council, panel council on being specifically asked as to whether the 2/2/2013 NOC was issued, specifically stating that the subject land is not put in acquisition, comma, he concedes that such NOC was issued. First, then we asked him, after the issuance of corrigendum dated 12/8/2013, comma, whether the NOC has been rescinded. He concedes that it has not been. First, when we asked him again whether pursuant to corrigendum any individual notice was served to the landowner in Writ Appeal 417 of 2023, he concedes that no personal notice was issued. All right. Any further argument?
My lord asked a question back to the reading of how we are trying to develop that. But to that, again, as you all also said, there generally what happens is when petitioners come seeking for lapsing, so at that time we say that there is no lapsing. And when we have to justify a substantial implementation, that time we say that this is all that we have done, this is how we are. So there, when they have not sought for lapsing on that ground, but there was no occasion for us to have sought. This we produced it because at the stage when the court put it up to them, that the house will not be in fact considered that the house property will allow them to retain in the same place. But the land, because his consent was 50% given to be in the same place. We said we can't give it because roads and other things are coming. So for that, we have produced all these things. So we say house we will allow you to retain. We wanted the well also to be retained. That is we can't give it. So at that stage, in respect of all other people, that in respect of all other people, we have already done that and we have earmarked all the plots where there is no dispute at all. So now this particular portion of the land, now we cannot leave it out because then our implementation of our scheme for that becomes. If I can understand, if it was at the corner and it is there, something he was talking to the corner of the land. But here for that, we at that stage, the court was looking into that. We then showed all these things. We also consider that. Sketch we have produced money.
Sketch is produced to show that this land where it is situated.
And where all is.
One second. But we were 123 acre or were consented where it comes and it comes in the way of implementation is nothing of that.
Where what road is coming up mentioned money. We have mentioned. Where all is coming under one separate thing we have mentioned. We have pointed out where the sewage lines are coming, where the scheme.
My lord, the reply adake, my lord, I filed application for appointment by a commissioner to establish 50% of the lands have been developed by the landowners during the preliminary notification and a final notification. Now, virtually, my lord, yes, ಸ್ವಲ್ಪ ನಿಲ್ಲಿ ಸ್ವಲ್ಪ ನಿಲ್ಲಿ ನಾನು ಅವ್ರು ಬಿಡೋದಿಲ್ಲ ಅಲ್ಲ ಸ್ವಲ್ಪ ನಿಲ್ಲಿ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೇನೆ ಆಮೇಲೆ ನೀವು ಹೇಳಿ ಮೈ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಕಮಿಷನರ್ because they expected to issue a final notification within a reasonable period of time. My lord, I have not developed it. But in the area, my lord, in the which is acquired, the 50% of the my lord lands or the landowners, they have constructed a building and they are staying now. That's why an application for appointment of commissioner to show that my lord now because of their inaction, now the final notification to support my case, my lord, I have filed application for appointment of commissioner. Yes,
after the preliminary notification was issued, why did you go? Why others, if others have put up construction, what is their fault?
No, their fault is 7 years were slept over the matter. They thought, my lord, they will not implement the, my lord, the scheme. Preliminary notification ಕೊಟ್ಬಿಡೋದು ಮಲ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
That is not applicable to the acquisition under this sector. Yavudu, which is that act ಕೊಡಿ ನಮ್ಗೆ ಕೊಡಿ ನಾವು ನೋಡ್ಬೇಕಲ್ಲ ಅದು ಏನು ಅಂತ ಅನ್ಕೊಂಡು ಅದಿತ್ತು ಅಂದ್ರೆ ನಮ್ದು
They cannot do anything. They cannot alienate. They cannot develop. And they do it at their own risk. That also the Supreme Court says.
No, that is.
ಅವ್ರು ಓದ್ಕೊಳ್ದಂಗೆ ಬಂದಿರ್ತಾರೆ. ನಮ್ದೊಂದು ಜಜ್ಮೆಂಟ್ ಇದೆ, ತೆಗೀರಿ ಅದ್ರ ಮೇಲೆ. ನಮ್ ಜಜ್ಮೆಂಟ್ ಇದೆ, ನೀವು ನೋಡಿಲ್ಲ. ಅದು ಎಲ್ಲರಿಗೂ ಅಪ್ಲೈ ಆಗಲ್ಲ. ವೆರಿ ಪರ್ಟಿಕ್ಯುಲರ್ ಆಕ್ಟ್ಸ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಏರಿಯಾಕ್ಕೆ ಅಪ್ಲೈ ಆಗತ್ತೆ ಅಂತ ನಾವು ಬರ್ದೇವಿ ಜಜ್ಮೆಂಟ್ ಕೊಡಿ. ಎನಿವೆ ಆಫ್ಟರ್ನೂನ್ ಬನ್ನಿ, ಕೆಲವು ಕ್ವಶನ್ಸ್ ಇದೆ ನಮ್ಗೆ ಆನ್ಸರ್ ಮಾಡೋಕೆ ಇಬ್ರು.
ಇಲ್ಲಿ ನಾಗಿ 18 ನೋಡು.